Hey, Natalie. Natalie, can you hear me?
Good morning, Phil. How are you?
Good. How you doing?
Oh, I can't hear you.
Can't hear me?
I can't.
Still can't hear me?
Oh, now I can hear you. Yeah.
Okay. Thank God. Hey, everyone. So we are streaming. Natalie, can you hear me? Great.
Yes, I
We are
can.
streaming live on YouTube right now, just so everyone knows. It looks like are waiting for just one juror in the other courtroom to sign in. And once that juror does, we should be good to go. And we should be able to start in 10 minutes or so, right on time. To the extent that any of your teammates or witnesses, et cetera, are not in the courtroom, please just let them know that we're going to get going in a few minutes, and they should come into the courtroom now. So it looks like we have everyone that we need in terms of jurors and judges in both courtrooms. And so to the extent that any of your teammates are still kind of filing in, just let them know that everyone's here that needs to be here, and we're good to get going right at 11. Hey, Amanda, can you hear me? I think she may. Hey, I'm really going to test your Zoom skills today.
Gonna send me back to 2?
I got to send you back to 2. I'm so sorry.
It's okay. I was just looking at this. I was like, I've judged one of these teams.
That's right. Now I'm realizing why I had you in courtroom 2 originally. So great. Thanks for doing that.
Okay, one sec.
Hey, Tara, can you hear me?
Yes.
All right, you said you wanted to test your side-by-side mode?
Yes.
All right, so I'm going to share my screen. Can you see my screen now?
I can.
Do you see view options at the top now?
I can.
Okay, so when someone shares their screen, you'll be able to see view options, and then you can switch to side-by-side mode. But if no one's sharing their screen, you won't be able to see view options. So that's when you have to change it. But the good news is if you change it now, you'll never have to change it again.
It's already in side-by-side mode. Yesterday, I was not able to see any of the exhibits. I had to go to toggle back and forth between the case pack and my Zoom.
Well, hopefully we don't have that problem today because it looks like what I just shared just worked. So we should be
Okay.
good. Okay.
Excellent. Thank you very much.
All right.
Yes.
I'm just going to do one more quick conflict check to make sure I didn't make any mistakes, and then I'll give you guys the thumbs up in just a minute or two. Is there anyone from either team that is not here that we're waiting on? If so, can someone from either of the teams just speak up quick?
We are all here
Great.
for process.
Defense is all present also.
Excellent. Be with you in a sec. So we're going to get going in a minute, but let me just quadruple check. Jurors Fuentes, Nye, Tierney, and Dixon. Can you all hear me?
Yes.
Okay.
Dixon,
Okay, I see Juror Fuentes, Juror Tierney, there's Juror Nye, she's good, and Juror Dixon is good. All right, excellent. Judge Adio, it is your courtroom. Whenever you're ready to start, we'll get going. I'm going to have this on mute, so to the extent that there are any issues, you just put it in the chat, and I'll get to it when I can. Okay?
Perfect. Thank you, Phil.
Excellent.
All right, so now that everyone's here and we've been given the all clear to get started, let's call the case of State of West Carolina v. Timothy Reg Adio. If any of you have any difficulty pronouncing that, just call me Judge A, that's fine. Scoring judges, please look to the two buttons on the lower left of your screen, and please turn off your audio and your video. These should remain off until trial ends. You should also have your video set to hide all non-video participants. This means the only people on the screen right now should be the advocates and myself for your viewing. All right, so now can the attorneys please make their appearances for the record?
Good morning, Your Honor. My name is Carly Gubernick, and I, along with my co-counsel,
Good morning, Your Honor. My name is Alan Carlson.
we're Team 112, and we're representing the defendant today, Mr. Timothy Ray.
Good morning. State, can you please make your appearances?
Good morning, Your Honor. Gohar Tamizian, first name spelled Gohar, last name spelled Tahmizian, here on behalf of the prosecution with my co-counsel.
Good morning, Your Honor. Noelle Areola, last name Arreola, here on behalf of the prosecution. And when Your Honor is ready, we have one pretrial motion and some housekeeping matters.
Yes, just one moment. State, can I have your team number just for ease of scoring?
Yes, team number 103.
Thank you. All right, State. So yes, let's proceed to motions in limine.
Your Honor, the defendant Timothy Ray is on trial today for murdering his 6-year-old son by strangling him after the boy spilled apple juice on the defendant's laptop. The defense has filed notice that they intend to raise an insanity defense, claiming that the defendant suffered from schizophrenia. It is the prosecution's contention that the defendant is in fact malingering. In support of their insanity defense, the defense has hired Major Shane Riley, a military forensic psychiatrist. In Dr. Riley's report, there is mention of an interview with the defendant's father, who is not a mental health professional, who believes that the defendant's mother may have suffered from some type of mental illness and was institutionalized as a result. But the defendant's father could not provide any information as to whether she was formally diagnosed, when she was institutionalized, or even where this information comes from. We move to exclude any reference to this information as inadmissible hearsay under Federal Rule of Evidence 802. Additionally, this evidence does not meet the admissibility standard for Federal Rule of Evidence 703, which does allow expert witnesses to testify to otherwise inadmissible hearsay. References to this material can be found on the bottom of page 62 and on the bottom of page 65.
Defense, what is your response?
Yes, Your Honor. So in regards to the hearsay objection, under 803.4, this is an exception to hearsay. These were statements made for the purposes of a medical diagnosis. Psychiatrists regularly use collateral information, such as interviews with people that know their patients best. That would be Timothy Ray's father in this instance. This information was provided to Dr. Riley for the purposes of diagnosing Timothy Ray. Further, like I just said, such interviews are collateral information that are reasonably and usually relied on by psychiatrists. Thus, it is admissible evidence under 703 to the point that there is no information or about a diagnosis specifically. The information that is relied on by both experts in this case is the fact that she did have severe mood swings and she was in fact institutionalized for those mood swings and for her symptoms. No one knows about that better than someone that is married to the person suffering from a severe mental illness. And Your Honor, based on all of that, under 803.4 as well as 703, this information is admissible in this case.
State, any last words?
Yes, Your Honor. First, to the 703 response. While experts are allowed to rely on hearsay, the jury is only allowed to consider that hearsay if the proponent of the evidence, the defense in this case, can prove that the evidence substantially, the probative value of the evidence rather, substantially outweighs any prejudice, essentially reversing the balancing test under Federal Rule of Evidence 403, and creating a presumption that the hearsay evidence is inadmissible. Here, the prejudicial impact of admitting this evidence is high, as we lack any information as to what specifically the mother was suffering from. Therefore, this invites the jury to speculate that she may have suffered from schizophrenia, which then would lead them to believe that the defendant is therefore more likely to suffer from schizophrenia. Additionally, Mr. Ray's father is not going to be testifying here today. We will be unable to question him on the source of this information as well as test the veracity of it. In regards to the response to hearsay under 803.4, the problem with this is that to counsel's argument that no one would know this better than the person married to him, the two were separated for years before she was allegedly institutionalized. And again, we have no idea how the father came across this information or how many layers of hearsay are actually at play. The father has given no indication that he knew exactly when she was institutionalized, where she was institutionalized, and just has no real information as to where this information comes from at all.
All right, counsel. So I'm going to grant your motion in part and deny it in part. I agree with defense counsel that this specific testimony falls under an exception to hearsay for 804 purposes of medical diagnosis. So I will allow Major Riley to testify to that specific hearsay statement that he learned from Abe Ray. However, counsel for the state, I do agree with you that it would be speculative for Major Riley to take the stand and then try to opine as to the mother's specific mental illness when my understanding is there's no evidence specifically of what mental illness she suffered from. And so for that reason, I will not allow Major Riley to speculate as to any specific mental illness Cindy Ray may have been suffering at that time in which she was institutionalized. However, Major Riley will be able to tell the jury that fact, that his mother was in fact suffering from a mental illness. Do you understand my ruling?
Understood,
do.
Your Honor.
Okay, perfect. So State, do you have any other motions in limine?
No, Your Honor, no further motions, only housekeeping matters.
Okay, before we turn to housekeeping matters, defense, do you have any additional motions in limine?
Yes, Your Honor. We have 2 motions in limine for you today, as well as 2 stipulations that were agreed to pre-trial. Your Honor, in this case, the jury will hear about a man who was suffering from severe schizophrenia when he killed his 6-year-old son. We don't dispute today that Timothy Ray physically caused the death of Nathan Ray. The only legal issue before the jury is whether we proved the insanity defense by clear and convincing evidence. In that context, Your Honor, there are 2 photos in this case, one of the child, Nathan Ray, and one of his bedroom filled with his toys. These are exhibits 29 and 27, respectively. We move to exclude these photos under Federal Rule of Evidence 403 because all they'll do is inflame the jurors' emotions. Again, we don't disagree that Timothy Ray physically caused the death of Nathan Ray. So showing these items will just inflame their emotions and make it more difficult for the jury to do their job today, which is to determine Mr. Ray's mental state 2 years ago when Nathan Ray died.
All right, before I turn it over to the State for response, just a note to each advocate, please also reference the page number of an exhibit, just for ease of reference for both myself and the evaluating jurors. Now, State, what do you have to say in regard to their 403 objection?
Yes, Your Honor. First, I will talk about Exhibit 29, which is a photo of the boy, Nathan Ray. So we have alleged that the defendant murdered his son, Nathan Ray, and therefore we have an obligation to prove that. This photograph is part of that proof. While the defense may feel that certain parts of this case are not important, they have chosen to plead not guilty. So that places every issue at every element of this case an issue, such as, and that includes identity. This photo is not bloody, it's not graphic, and it's not otherwise likely to cause an emotional reaction, especially since the jury is undoubtedly going to find out that this was a 6-year-old boy that the defendant killed. And then as far as Exhibit 27, with all due respect, I believe that the opposing counsel has mischaracterized this photo. It's not just a room full of his toys. It is the belt. It is in fact the murder weapon that was used in this case. And again, this is relevant because it corroborates the defendant's statement, which is particularly important given that they have pled both not guilty and not guilty by reason of insanity. This plan that he claims to suffer from a mental disease, which caused him to hallucinate and keep him from understanding when something was real. But this is proof that the defendant knew right from wrong, that he was able to understand that using a grown man's belt around a 6-year-old boy's neck would absolutely cause him irreparable harm.
Defense?
May I respond?
Yes, you may.
Sorry, I just want to get a quick page number. So first, in response to the Exhibit 29 and counsel statements in regards to that photo, we're not disputing that this was a death of a 6-year-old boy. There will be plenty of testimony to that end today. And also the autopsy report in this case, which is Exhibit 6, has already been stipulated as admissible. That's on page 53. That autopsy report includes information about Nathan's age, his height, his weight. That will tell the jury everything that they need to know about Nathan Ray. There also will be substantial testimony about the fact that he was a 6-year-old boy. And that's not something that we're hiding today. That testimony will be shared with the jury. Showing a photo of Nathan at 6 years old just smiling, it doesn't do anything for the jury other than inflame their emotions. In regards to Exhibit 27, Your Honor, we have no objection to the jury seeing a cropped photo of the belt itself. We understand that that was the murder weapon, and we're okay, and we will stipulate that that can be shown to the jury. We just ask that the photos and the surrounding area, Nathan's toys and the surrounding area around that belt be cropped out of the photo, because that only serves to inflame the jurors' emotions and to add to the fact that, again, there will be plenty of testimony about the fact that this was a 6-year-old boy.
For the
May I
state
respond, Your Honor?
regard, yeah, but let me ask you a question specifically with regard to Exhibit 27. would you
Yes.
be willing to stipulate to constructively cropping the exhibit just to show the murder weapon, the belt?
Your Honor, the problem I have with that is that there's a few things. One, it doesn't give the scale of what this grown man's belt is next to a little boy's toys, which again is just going to go to an element that we have to prove again because they pled not guilty of malice aforethought. Now that requires wanton and reckless disregard for human life. And to show that this belt, that knowing that the fact that the defendant was able to take this belt, put it around a young boy's neck and squeeze is enough to prove malice aforethought. We need the perspective of that photo next to the boy's toys. This also corroborates the defendant's testimony that he was the one that went and killed Nathan in his room. So it is very important that the jury see the belt, where it is, as well as the background.
Your Honor, may I respond briefly?
Yes, briefly.
I'm happy to stipulate that this happened in the bedroom. Based on counsel's argument, it's not relevant in this case what the size of Timothy Ray's belt was relative to a teddy bear that was in Nathan Ray's bedroom. That does not go to show anything about Timothy Ray's mental state. We're happy to stipulate that that the events in this case happened in Nathan's bedroom.
I suspect state would not be willing to stipulate to that. Is that correct?
No, Your Honor, not at this time.
So here's my ruling. So with regard to Exhibit 29, the photo of the decedent, that's coming in. So your motion will be denied. It's customary in a criminal trial for there to be a life and death photo. And I agree with state that it's not particularly gruesome and it's important for the jury to see who the victim was. So for Exhibit 29, that's in. For Exhibit 27, defense, I do think you made a good point that the size of the belt in relation to the items surrounding it are not of any importance or significance in today's trial. However, my understanding is that this is the photo that the detective or the forensic team took, and it's important to actually put in the exhibit as it was seen and as it was photographed. I think that's relevant. And so for that reason, I'm also going to respectfully deny your motion, although I thought you made good points on it. Any other motions from the defense?
Yes, Your Honor. One more motion. As the defense counsel in this case, we made a decision not to allow the government psychiatrist, Dr. LaGreca, to interview our client. We ask that the prosecution be barred from mentioning this fact, as a legal team's decision is not relevant, again, to Timothy Ray's mental state 2 years ago when Nathan died.
Response, state.
Yes, Your Honor. This is going to go to Dr. LaGreca's credibility. Dr. LaGreca did not have a chance to interview the defendant in this case, and therefore we need to state that even though she was not able to interview the defendant, she has been well qualified to come to her opinion, and we just fear that this goes directly to her credibility, and we need it to be admitted. We only plan to use it to say that the defendant was not allowed to speak with Dr. LaGreca, and that even though he was not, she was still able to form an opinion that she bases her medical experience and to a reasonable degree of medical certainty.
Defense, let me ask you this. Are you going to cross Dr. LaGreca on the fact that she did not interview the defendant to attack her credibility?
No, Your Honor, we're happy to stipulate that Dr. LaGreca wanted to interview Mr. Ray and that she was unable to at no fault of her own. We assure the court that we'll not attack Dr. LaGreca's opinion at all because she wasn't able to interview the defendant himself.
Okay, so based on that representation that you just made, if you were not going to cross LaGreca on the fact that he or she was not able to actually interview the defendant, then I do not believe that there is any necessary need for the state to then explain the reasons as to why. However, if somehow it comes out, a state where the defense is attacking that specific fact, please feel free to re-raise your motion. So at that time, I will grant defense's motion with regard to LaGreca mentioning that she did not interview the defendant and for what reasons. Any other matters from the defense regarding motions?
Your Honor?
Yes, sure.
Sorry, may I be heard one last time on the LaGreca, on the argument that was just made?
Yes, briefly.
Thank you. In addition to we have the burden to prove that the defendant was not schizophrenic and was in fact malingering. One of the factors of malingering is uncooperativeness, and therefore the fact that the defendant was not willing to meet with Dr. LaGreca goes exactly to this, one of the factors of malingering, which is uncooperativeness, and therefore makes it more likely that the defendant was malingering as a result.
Well, let me just clarify one thing. You do not have the burden. You may
Pardon
have
me?
to rebut that their
Pardon me.
insanity
That's what
defense.
I-
However, they have the burden to prove insanity first, and then it is up to you then to rebut their theory. And as a result, because of that, that's even more reason as to why I'm not inclined to let this in if they're not going to attack your expert on that. Based on my review of the materials, LaGreca has more than enough qualifications and background to provide a testimony regarding malingering without having to get into the fact that she did not interview the defendant if the defense isn't going to attack her on that. And so I'm going to let my ruling stand. As I said, if they get into it, please feel free to re-raise it. Any other motions from the defense?
I just have 2 stipulations that were agreed to pre-trial to bring to your honor's attention.
Yes, please.
Your Honor, under Federal Rule of Evidence 704B and the Pasquarella case that is binding precedent in this jurisdiction, both sides have agreed that no expert may give an opinion on whether Mr. Ray did or did not have the intent to kill or the ability to tell right from wrong at the time of Nathan's death. This was agreed, again, by both parties that neither expert will testify beyond the bounds of 704B. That is also understanding that under Pasquarella, experts are able to discuss general qualities of severe mental diseases that could cause someone to know right from wrong. They just cannot testify specifically as they relate to Timothy Ray.
Yes, that's my understanding of the case as well. So State, did you stipulate to that matter? Yes, I saw head nodding. So for our constructive court reporter, can I get an affirmative yes on the record, please? Thank you. What's the second stipulation?
Yes, and then opposing counsel has also agreed pre-trial to allow Exhibit 3, which is, I'm so sorry, I'll bring up the page number for you. Exhibit 3 starts on, I'm so sorry, on page 40. It's pages 40 to 44. That is the interview with the defendant. Counsel has stipulated pre-trial that that will be admissible today.
All right, so State, you stipulated to this matter and it is admissible. So stipulated?
Yeah.
All right. So now, if there's no other stipulations or motions, let's move to housekeeping. State, what are your housekeeping matters?
Yes, Your Honor, we would also like to draw your attention to 2 stipulations we made with opposing counsel.
Sure.
During meet and confer, we agreed to pre-admit into evidence Exhibit 6, which can be found on page 53, Exhibit 7, which can be found on page 54, and Exhibit 8, which can be found on page 55, Exhibit 17A, which can be found on, so sorry, Your Honor.
I'm there, it's page 93.
And Exhibit 18, which can be found on page 95.
All right, defense, so stipulated to that matter?
Yes, Your Honor. I would just like to bring to the court's attention that part of that stipulation was that Exhibit 18 would be the only photo of the photos in the state park of Nathan's burial that will be brought in during trial today.
Okay, understood. State, was that your understanding as well?
Yes, Your Honor, that's correct.
Okay. And did you have any other stipulation, State, that you wanted to bring to my attention?
Yes, the parties have stipulated on page 4, stipulation 1, that exhibits have been pre-numbered and they shall retain those numbers regardless of the order they are introduced in trial.
In defense, did you agree to that?
Yes, Your Honor.
All right, any other housekeeping matters from the State?
Yes, Your Honor. During the course of trial, counsel may ask to approach sidebar. We ask that this be done constructively so that the other judges could hear our arguments.
Yes, I agree. It can be done constructively. However, every time that you believe there's a basis to go outside the presence of the jury, I want you to ask me, okay?
Would Your Honor prefer that we formally tender the expert witnesses in this case?
Yes, please formally tender.
Your Honor, at this time, we would like to exclude all witnesses under Federal Rule of Evidence 615 with the exception of the defendant, the detective officer, and expert witnesses.
And defense, are you willing to agree to detective officer remaining in the courtroom? Because I think it's okay for experts and the actual accused. But do you
Yeah.
agree to the detective officers?
Your Honor, my understanding is that fact witnesses should be sequestered in this case under the rules of this jurisdiction.
Yeah, I'm inclined to agree. Detective Booth and Officer Wentz cannot remain in the courtroom to hear other testimony until after they've given theirs. Understood, State?
Understood, Your Honor.
Perfect.
And lastly, we also move that all witnesses be constructively sworn in.
Yes, makes my life easier, so for sure. Any other housekeeping matters from the state?
With that, Your Honor, prosecution is ready for trial.
Okay, defense, any housekeeping matters?
Your Honor, with that, the defense is ready to move to trial as well.
All right, so we will now hear opening statements from each party. Everyone should make sure they are in speaker view. That button is in the upper right of your screen. Attorneys, please remember to mute your audio when the other attorney is speaking. And State, you may proceed when you are ready.
When Jessica Ray went to pick up her son Nathan from school on October 18th, 2018, and she was told he wasn't there, she tried not to think the worst. Nathan was probably just with his dad. When Jessica went to the dad's house and Nathan wasn't there, she tried not to think the worst. Nathan's dad probably just took Nathan somewhere as a way to get back at her. Then she gets the call that's every parent's worst nightmare. It was the police calling to tell her that her son's 6-year-old body was found by dogs in a local park and that the boy's father, her estranged husband, had confessed to the murder. During this trial, there will be a couple issues for you to decide. One is whether the defendant, Timothy Ray, is guilty of murdering his son, Nathan. And by the end of this case, it will be clear that the answer to that question is yes. The other is whether Timothy Ray suffered from a mental disorder that caused him not to know what he was doing or from understanding that it was wrong. And by the end of this case, it will be clear that the answer to that question is no. The evidence you'll hear today will lead you to those answers by establishing two things. First, the defendant knowingly killed his son by strangling him to death. And second, the defendant understood that killing his son was wrong. So let's talk about that first point, that the defendant knowingly killed his son by strangling him to death. The morning of Nathan's murder started like most other days, with Nathan eating his favorite cereal while enjoying a cup of apple juice. And 6-year-olds doing what 6-year-olds do, Nathan spilled apple juice right on his dad's laptop. And while kids spilling juice is common, the defendant's reaction was anything but normal. He started screaming at the boy so much that Nathan burst into tears and ran upstairs to his room. Still screaming and yelling, the defendant follows Nathan upstairs and forces him to do exercises as punishment. Eventually, little Nathan's body can't take it, so he stops exercising and begins calling for his mother to help him. But she's not there. She can't hear him. But the defendant can, and hearing Nathan screaming for his mother is the last thing the defendant wants to hear. So he storms off to his bedroom where he picks a belt from his closet and returns to quiet his inconsolable son. He walks into the room and hits Nathan with the belt a few times, but Nathan just won't stop screaming. So the defendant does something that will force Nathan to stop screaming for his mother. He takes the belt, wraps it around Nathan's neck, and squeezes. Nathan gasps and struggles for his last breath, and suddenly, silence. Nathan's 44-pound body goes limp. And after taking the life of his only son, the defendant was faced with the issue of what to do. So he begins looking for ways to hide what he'd done. And that brings me to the second thing the evidence will show, that the defendant understood that killing his son was wrong. In today's case, you'll learn that the defense is claiming that the defendant suffered from schizophrenia so severe that he was not able to understand that killing his son was wrong. But his actions after killing Nathan will show you that's simply not true. After strangling his son to death, you'll get to see the internet searches the defendant conducted, looking for ways to get rid of a body, and countries that don't extradite people for murder. You'll also learn that ultimately the defendant decided to hide Nathan's body by putting it in a plastic trash bag and burying it in a makeshift grave in Brandywine Park. Unfortunately for him, the defendant was stopped at a DUI checkpoint 2 days after killing Nathan, with the shovel and the plastic bags he used to hide Nathan's body still in the back seat of his car. You'll also hear that once the police officers had the defendant step out of the car at the checkpoint, the defendant started acting strangely. An attempt by him to make it look like he was suffering from severe mental illness. But today, you'll hear from Dr. LaGreca, an expert forensic psychiatrist with 25 years of experience evaluating people for mental illness. And what Dr. LaGreca will tell you is simple. She'll tell you that the defendant suffered from anxiety and depression, both of which are recognized mental illnesses. But that based on the evidence, it will be clear that the defendant's mental illness wasn't nearly severe enough to keep him from knowing what he was doing as he strangled Nathan, or from understanding that it was wrong. Dr. LaGreca will also tell you that based on her review of the defendant's medical records and all of the facts of this case, he was malingering, which is just a psychiatrist's way to say he was faking his symptoms. Members of the jury, after seeing all of the evidence and hearing all of the testimony in this case, it will be clear that the defendant murdered his son out of anger and not because of any mental illness. That's why, at the end of this trial, my co-counsel will come before you and ask you to return the only verdict consistent with the law and demanded by the facts, a verdict finding him guilty of murder.
Thank you, counsel. Defense, when you're ready.
Yes, Your Honor. Timothy Ray is not a criminal. He is not a father who maliciously killed his only child. You see, mental illness runs in Mr. Ray's family, and he has suffered from a severe mental illness for some time now, including extreme paranoia, voices, and hallucinations. And his severe mental illness, his schizophrenia, not only caused Mr. Ray to lose his sanity, but caused a far greater tragedy, the death of his son, Nathan. This is a case about a severe mental illness that went unnoticed, unchecked, and untreated. If today's trial was about whether Nathan's death was a tragedy, well, it would be over before it even began because everybody agrees that the death of a child is unquestionably tragic. But today's trial is about whether Mr. Ray is criminally responsible or whether his conduct was a result of a severe mental illness. And that's what the insanity defense is about. Ensuring blame is properly placed on those who understood what they were doing, when they were doing it, not on those that suffer from a sickness. Mr. Ray is 34 as he sits before you today, but his history with mental health issues started when he was a kid. At the age of 6, his mother was institutionalized for symptoms resembling that of schizophrenia. By age 10, he himself began to hear voices. And in his 20s, he suffered from depression, anxiety, and eventually extreme paranoia. And this mental illness was active in the years leading up to Nathan's death. In 2015, 3 years before Nathan died, Mr. Ray became paranoid, hearing voices that his wife was cheating on him. A year later, he experienced visual hallucinations. His wife described that he would go weeks without showering. He would often lock himself in the bathroom for hours at a time, refusing to come out. Mr. Ray was battling a serious mental illness, and he was losing. In the months leading up to Nathan's death, a series of events occurred that broke Mr. Ray. In 2018, his wife had an affair. All of a sudden, the voices that had been telling Mr. Ray for 3 years that his wife was cheating on him, well, they were telling the truth. The voices became real. And these voices became more frequent, more commanding. The voices told Mr. Ray that his son and his wife were planning to leave him. They told him that his wife was planning to sabotage him. Remember, to Mr. Ray, the voices were right about the affair. Why wouldn't they be right about this too? Only days before Nathan's death, Mr. Ray's wife told him she was filing for divorce. She was leaving him. Once again, the whispering voices became reality. And this brings us to the day of Nathan's death. That morning, Nathan spills juice on his father's laptop. The voices tell him it's a trick. They tell Mr. Ray that the juice is part of his wife's plan to split up the family. And so when they tell him to punish his son, he does. But what you are going to hear from Dr. Riley, a psychiatry expert with decades of experience, especially in treating those in the military, is that Mr. Ray was in a schizophrenic episode the day Nathan died. Dr. Riley has treated this patient before, first in 2010. And Dr. Riley spoke with those that knew Mr. Ray best: his father, his boss, his ex-wife, Nathan's own mother. And the doctor that's treating Mr. Ray right now corroborates Dr. Riley's diagnoses through their prescriptions and their treatments. Dr. Riley found and will explain to you using tools of science that Mr. Ray is a schizophrenic, and that schizophrenia is a disease that can prevent someone from knowing the nature and quality of their acts, or whether they are right or wrong. The prosecution's case at bottom is that they can prove that this guy is a cold-blooded murderer beyond a reasonable doubt. But you will know that is not true because Mr. Ray was insane. There will be clear and convincing evidence that Mr. Ray suffers from schizophrenia, and that as a result of that severe mental illness, he did not know the right from the wrong of what he was doing. Everyone wants justice for Nathan Ray. But that justice is not found by making a criminal out of a man who suffered from a severe mental illness that went unnoticed, unchecked, and untreated. And that's why at the end of this trial, my colleague, Ms. Gubernick, will come before you and ask for the only just verdict in today's case. Timothy Ray is not guilty by reason of insanity. Thank you.
Thank you, counsel. Before the state calls its first witness, I will ask everyone to switch to gallery view. That button is in the upper right of your screen. This will allow you to see the attorneys and witnesses at the same time. So state when you are ready, please call your first witness.
Your Honor, the state calls Detective Blake Booth to the stand. Good afternoon. Please introduce yourself and tell us where you're from.
Good afternoon. My name is Detective Blake Booth, and I'm from here in Skelton.
What do you do for a living?
I am a detective in the homicide unit at the Skelton Police Department.
How long have you worked for Skelton PD?
For over 23 years now.
Detective Booth, how did you become involved in this case?
On October 19th, 2018, I received a call about a suspect that was stopped at a sobriety checkpoint. It was a suspect in a missing person case that I was assigned to. So I went down to the checkpoint, spoke with the officers, and had that suspect taken back to the station for an interview.
Your Honor, I have the missing persons report that Detective Booth just mentioned and has been marked as Exhibit 7 and has been pre-admitted into evidence. Permission to publish the exhibit for the jury?
Yes, granted.
Detective Booth, what is Exhibit 7?
It's the report from the missing person case that I was just talking about. I wrote it after speaking with Jessica Ray, who is the mother of Nathan Ray, the missing child.
Did she say where Nathan was supposed to be?
She said that Nathan was supposed to be at school, but that he had been missing for several days and Mr. Ray wasn't returning her phone calls. They were separated and weren't on good terms, so she thought that Mr. Ray may have been trying to keep Nathan from her.
Now, Detective Booth, did you know Nathan before you became involved in the investigation?
I did. Nathan and my son played soccer together.
Would you recognize a photo of Nathan if you saw it?
I would.
Your Honor, I have a photograph that has been pre-marked as Exhibit 29 for identification and can be found on page 106 of the record. Detective Booth, do you have a copy of Exhibit 29 for identification?
Yes, I do.
Do you recognize it?
Yes.
What is it?
It's a photograph of Nathan Ray.
Is Exhibit 29 a fair and accurate depiction of Nathan before his death?
Yes, it is.
Your Honor, prosecution moves Exhibit 29 into evidence.
Based on my ruling in the motions in limine, that will be granted. You may publish as you see fit.
Detective Booth, who was the person you brought in for questioning?
Nathan's father, Timothy Ray.
Did you see Timothy Ray here on the court screen today?
I did.
Could you describe him to us and tell us what he was wearing?
He has brown hair and he was wearing a white shirt with a blue tie.
Your Honor, may the record reflect that the witness has identified the defendant.
The record shall so reflect that in-court identification.
Detective Booth, you said earlier you had the defendant taken down to the station so you could interview him. Did you interview him?
Objection, Your Honor. If we're no longer talking about the photo of Nathan, can we please take it down?
My apologies, counsel. Can you just read back your last question to me?
Did you interview the defendant?
I'm inclined to agree. Sustain.
Yes, I did. Once we got back to the station, he agreed to talk to us about his son's disappearance.
Where did he say Nathan was?
He told me that he killed Nathan on October 17th, 2018.
Did he tell you why?
Yes. He said that he and Nathan were having breakfast that morning, and that Nathan spilled juice on his laptop. He said that he killed Nathan for punishing him for spilling the juice.
What exactly did the defendant say happened after Nathan spilled his juice?
He said that Nathan started yelling at Nathan, and then Nathan started screaming and crying and ran to his room. So the defendant followed him upstairs and made him do exercises for punishment.
What kind of exercises?
Jumping jacks, running in place, high knees, which is where you run in place, but you bring your knees up really high.
What else did the defendant say?
He said that after a while, Nathan refused to do any more of the exercises and he kept screaming and crying for his mother. The defendant said that he went to his room, grabbed a belt, and started spanking Nathan with it.
What did the defendant say happened after he started hitting his son with a belt?
Nathan was screaming and crying out for his mother, so the defendant wrapped the belt around Nathan's neck and strangled him until he stopped moving.
And what did the defendant do after Nathan stopped moving?
He said he took his son's body and buried it at Brandywine State Park.
Detective Booth, was this interview recorded?
Yes, it was audio and video recorded.
Do you still have a copy of those recordings?
No, I didn't have the recording saved, but I do have a transcript of the interview.
Detective Booth, after you interviewed the defendant, what did you do?
I got a team of officers and K-9 unit, and we went down to search for Nathan's body at the Brandywine Park.
And how long did you search the park for?
It was about an hour and a half before one of the dogs found Nathan's body right there, buried under some trees.
Your Honor, I have a photograph that has been marked as Exhibit 18 and pre-admitted into evidence. Permission to publish the photo for the jury?
Granted.
Detective Booth, what is Exhibit 18?
This is a photograph of Nathan's body as we found it at Brandywine State Park.
Now, Detective Booth, you said earlier the defendant was driving a car when he was stopped at the sobriety checkpoint. Was that car ever searched?
Yes, we searched the defendant's car, and that's where we found the bleach bottles, the shovel, and the black trash bags.
Your Honor, I have photographs that have been pre-marked as Exhibits 22 through 26 for identification. These items can be found on page 99 through 103 of the record. Detective Booth, do you have a copy of Exhibits 22 through 26 for identification?
Yes, I do.
Do you recognize them?
Yes.
What are they?
These are the photographs of the items that we found in the back of the defendant's car the night he was arrested.
Are these exhibits a fair and accurate depiction of the items you saw in the defendant's back seat as you first saw them?
Yes, they are.
Your Honor, prosecution moves Exhibits 22 through 26 into evidence.
Any objection?
Yes, Your Honor. 5 photographs of the interior of the vehicle becomes cumulative. The detective has already testified that there's a shovel, bleach, and black trash bags in the back seat, none of which the defense disputes. We are fine with 1 photo being entered, but not all 5.
Response from the state?
Your Honor, these are all different photographs. In some of the photographs, you can't see the shovel, you can't see some of the bleach, you can't see the plastic trash bags. As an offer of proof, we may publish the exhibit for you before we publish for the jury.
Well, I'm taking a look at it and state I agree. I think that each photo depicts different items. There's not a single photo that I think actually depicts all of them. And I think it's important for the jury to see each of the photos the detective took. And so I'm going to overrule your objection. This 20 through 26 will be admitted, published as you see fit.
Detective Booth, were the park and the defendant's car the only things you searched in your investigation?
No, I also searched the defendant's cell phone as well as his house.
Let's talk about your search of the defendant's phone first. Did you find anything there that was significant to your investigation?
Yes, I found a number of internet searches on the defendant's phone that were conducted the day after he killed his son.
Your Honor, I have a photograph that has been pre-marked as Exhibit 10 for identification. This item can be found on page 57 of the record. Detective Booth, do you have a copy of Exhibit 10 for identification?
Yes, I do.
Do you recognize it?
Yes.
What is it?
It's a screenshot of the internet searches that were conducted on the defendant's phone on October 18, 2018.
Is Exhibit 10 a fair and accurate depiction of what you found in the defendant's phone search history?
Yes, it is.
Your Honor, prosecution moves Exhibit 10 into evidence.
Any objection?
No objections, Your Honor.
It'll be admitted, published as you see fit.
Detective Booth, you also said you searched the defendant's house. Where does the defendant live?
He lives here in Skelton.
Did you find anything there that was significant to your investigation?
Yes, we found evidence of the juice spill on the kitchen counter, like the defendant told us, and we found a grown man's belt on the floor of Nathan's bedroom.
Your Honor, I have a photograph that has been pre-marked as Exhibit 27 for identification. This item can be found on page 104 of the record. Detective Booth, do you have a copy of Exhibit 27 for identification?
I do.
And do you recognize it?
Yes.
What is it?
It's a photograph of the belt that we found on Nathan's bedroom floor.
Is Exhibit 27 a fair and accurate depiction of the belt as you found it in Nathan Ray's bedroom?
Yes, it is.
Your Honor, prosecution moves Exhibit 27 into evidence.
Based on my prior rulings during motions in limine, this exhibit will be admitted and go ahead and publish, counsel.
No further questions, Your Honor.
All right, cross-examination.
Yes, Your Honor. Detective Booth, you're aware that the jury has to decide whether or not Mr. Ray was mentally ill on the day of his son's death. Is that correct?
Yes.
you're responsible for the audio and videotape of his interrogation not being preserved.
I did not preserve it, correct.
Now, that audio and videotape had the sound of his voice.
Yes,
It had what he looked like that night.
it did.
But because you didn't preserve the audio and video, the jury cannot see or hear Mr. Ray the night of his interrogation.
That's correct.
For those qualities, we have to rely on your memory.
Yes, as well as the transcript.
But your memory can't be trusted, can it, Detective?
Yes, it can.
Well, let's talk about that memory. You testified in a preliminary hearing, is that correct?
Yes, it is.
That was the first official hearing of this case.
I believe it is.
That was in front of a judge,
It was.
and you were under oath.
That's correct.
And that hearing was only 2 months after the interrogation, is that correct?
I believe so.
And when asked in that hearing if Mr. Ray ever accused you of being in the CIA, you responded, no, he never said anything like that. Those are your words, correct?
I believe I was referring to before he was in custody or before he spoke with me in custody.
But well, just a moment. When you were asked that question, did he accuse you of being in the CIA? Your response was, no, he never said anything like that. Is that correct?
Again, I was referring to the conversations I had with him before I interviewed him.
Well, Detective, when you were asked about the interview in particular, you said, nothing the defendant said was odd. It was a normal interview. That's what you said about the interrogation.
That's correct, and I still believe it was a normal interview.
Mr. Ray accused you of being in the CIA during that interrogation, didn't he?
That's what he claimed, but there was no way he actually believed that.
Detective, I'm not asking you about what you thought Mr. Ray believed. I'm asking you whether or not he accused you of being in the CIA. Yes or no?
Did he use the words, "Are you in the CIA?" Yes, but do I believe that it was an actual accusation? No, I do not.
Detective, I apologize. Just my question, please. Did he accuse you of being in the CIA? Yes or no?
He said those words.
And he didn't accuse you just once, but at least 3 times. Is that correct?
He used those words.
At least 3 times, correct?
I believe so.
And I say at least because the first time he accused you of being in the CIA was before the transcript was recording. Is that right?
That's correct.
Your Honor, permission to republish a portion of Exhibit 3, which has already been admitted into evidence.
Granted.
Detective, on page 41, lines 22 to 23 of the transcript, after being accused of being in the CIA, your response was, Mr. Ray, we've been over this. You asked me the same thing earlier, remember? When I gave you that waiver of rights form, you asked me if I was from the CIA. Those are your words, correct?
That is correct.
Thank you, Ms. Maurer. There's no recording of that conversation you had with Mr. Ray, is that correct?
No, he wasn't under Miranda for us to record at that time.
Right, we have no recording of when you got Mr. Ray to sign the Miranda form.
No.
Again, for those interactions, all we have is your memory.
Yes, I mean, we couldn't record before we had him waive his rights.
Detective, when Mr. Ray brought up the CIA, you didn't get a medic.
No, I did not.
You did not consult a mental health professional?
No, I did not.
You just kept interrogating him.
Yes.
At
I knew
2:17 in the morning.
I'm sorry, if I could just finish my answer.
Please.
Yes, would counsel please allow the witness to fully testify before you proceed with your next questioning? And the witness, I also instruct you to pay him that same courtesy. You may proceed, Detective Booth.
Yes, I knew that he knew who I was. He's seen me at soccer games, and he even referred to me by name at the end of our interview.
But Detective, just returning to my question, you continued to interview him after he mentioned the CIA. Is that correct?
That's correct.
And it was 2:17 in the morning.
Yes,
During this interview, Mr. Ray was visibly upset.
he was. I mean, he just killed his son.
The transcript tells us that he was talking about voices, doesn't it?
He mentioned they a few times, but I had asked him in the beginning of the interview if anyone else was there with him, and he said no.
Detective, but the transcript does show evidence of talking about voices, correct?
I believe I answered your question. Yes.
Let's take a look at the transcript together. Your Honor, permission to republish portions of Exhibit 3?
Granted.
On page 42, line 7 of the interrogation transcript, Mr. Ray said, "She tricked him to spill the juice on it because she wanted to take him away from me." I read that correctly, right?
Yes, you did.
Now on that same page, lines 22 to 24, he said, "You have to know how ashamed I am. You have to know how sorry I feel. I would have never done it if they hadn't told me to do. They told me to. They told me that she tricked him." I read that properly.
You did. That's what he said at first.
And you played into this idea that his wife was tricking him, saying, "She had him tricked too good if she was saying that. She sounds like a piece of work. How did you make him understand that she couldn't trick him like that?" Those are your words, correct?
Those are my words, but this is common practice when interviewing a suspect.
Detective, but just my question, those are your words, correct?
Those are my words, but it is common practice.
And you also said, "I bet you screamed it at him because he needed to understand."
That's what I said.
Now, Mr. Ray's behavior the night of his interrogation wasn't the only time you were alerted to potential mental health issues. Is that right?
I'm not sure what you mean by that.
Well, Jessica Ray shared with you her concerns about Mr. Ray's mental health. Is that right?
She didn't share concerns. When she called to report the missing person case, she actually thought that Mr. Ray was trying to keep Nathan away from her because they weren't on good terms.
Detective Booth, I'm actually talking about the phone call you had with her to report Nathan's body being found. You did call her to report that, correct?
Of course.
And when you called her, she was devastated,
Yes.
sobbing uncontrollably.
Yes.
And she told you, "I knew I should have never left Nathan alone with him when he was acting strange."
She did say that, but I mean, she was so just in the moment.
But detective, she told you, "I knew I should have never left Nathan alone with him when he was acting strange." Yes or no?
She did say that.
She also told you, "I knew he was going crazy."
That's what she said.
I'd like to talk about the interrogation and bring you back there. Your Honor, permission to republish portions of Exhibit 3.
Granted.
Mr. Ray told you, "I didn't mean for any of this to happen. I didn't mean to kill him." Correct?
Yes, he said that because he was feeling sorry for his actions.
Detective, I'm just asking what's in the transcript, and that is all. And I'm asking if I read it properly. "I didn't mean for any of this to happen. I didn't mean to kill him." Is that correct?
That is correct.
And then he said, "I didn't know what was happening."
That's what he claimed.
Thank you. Nothing further.
Any redirect for this witness?
No, Your Honor. May this witness be excused?
Yes, she may. Thank you, Detective Booth. State, call your next witness.
Yes, Your Honor. Prosecution calls Dr. LaGreca to the stand.
You may proceed when you're ready, counsel.
Good morning. Please introduce yourself to the jury and tell us what you do for a living.
Hello, my name is Dr. LaGreca, and I am a forensic psychiatrist. I'm also the program director of the West Carolina School of Medicine's Forensic Psychiatry program.
What's a forensic psychiatrist?
A forensic psychiatrist is a physician. We use our medical training to consult with patients, their attorneys, and sometimes courts to provide expertise about mental health issues that come up in a legal context.
What do you do as the program director for West Carolina School of Forensic Psychiatry?
I teach and supervise fellows in the forensic psychiatry program. I also oversee medical students in their general psychiatry rotation, and I'm also continuing to treat patients myself.
Please tell the jury about your education.
I earned my medical degree from the University of Pennsylvania, and I completed my psychiatry residency at UCLA. I then returned to UPenn to complete my forensic psychiatry fellowship.
You said that you continue to treat patients today. Did you practice as a psychiatrist before moving into academia?
Yes, after graduating and completing my training, I began my own private practice in New Jersey, where I treated patients with a variety of mental disorders.
How long have you been practicing?
23 years before I moved into my current position in 2017.
Have you ever been published?
I'm working on a paper on malingering arising in criminal cases involving capital punishment. It has yet to be published.
What's malingering?
Malingering means faking or exaggerating an illness. It's a term that psychiatrists use to describe a person who's faking or exaggerating mental health symptoms.
Are you a member of any professional organizations in the field of psychiatry?
Yes, I'm a member of the American Medical Association and the American Academy of Psychiatry and the Law, and I'm also a member and past president of the American Psychiatric Association.
Do you have any board certifications or licenses?
Yes, I'm board certified in forensic psychiatry and licensed in 3 states, New Jersey, West Carolina, and Pennsylvania.
Have you testified as an expert before?
Yes, 7 times.
Your Honor, at this time, the prosecution tenders Dr. LaGreca as an expert in forensic psychiatry.
Any objection or voir dire?
No objection to that tender, Your Honor.
All right, so Dr. LaGreca will be tendered as an expert in the field of forensic psychiatry. You may proceed, counsel.
Turning your attention to this case, how did you become involved?
I was asked by the prosecution to review the case and to give an opinion on whether or not Mr. Ray was suffering from a severe mental illness at the time he killed his son.
Are you being paid for your work today?
Of course. I'm being paid my normal rates, which are $500 an hour to review the case and prepare a written report, and a flat rate of $1,750 per day for my time in court, which includes my travel, my lodging, and my meals.
What specifically did you review in this case?
I reviewed the police reports, the crime scene photographs, witness statements, the defendant's medical records, the report prepared by the defendant's expert, Major Shane Riley, and the DSM-5.
What's the DSM-5?
The DSM-5 is the standard text that psychiatrists use to diagnose mental disorders. It lays out the symptoms for every mental disorder recognized by the psychiatric community.
After reviewing all of the materials that were available to you, were you able to come to an opinion on whether Mr. Ray was suffering from a mental disorder at the time that he killed his son?
Yes, I was.
Do you hold this opinion to a reasonable degree of medical certainty?
I do.
What is your opinion?
In my opinion, there was no evidence that any mental disorder played a significant role in Mr. Ray's actions at or near the time he killed his son.
Dr. LaGreca, you're aware that the defense is claiming that the defendant was suffering from severe schizophrenia at the time he killed his son.
Yes, I read that in Major Riley's report. In my opinion, Mr. Ray was actually malingering, meaning he was either exaggerating his symptoms or not experiencing any symptoms at the time of Nathan's murder.
Before we go any further, please explain to the jury what schizophrenia is.
Schizophrenia is a mental disorder suffered by less than 1% of the population. It causes a person to have a distorted perception of reality. They can have delusions, hallucinations, and disorganized thought or speech. People with schizophrenia may in turn withdraw from their relationships.
Your Honor, referring court and counsel to page 93 of the record, showing Exhibit 17A, which has been pre-admitted into evidence. May I publish for the jury?
Yes, you may, granted.
Dr. LaGreca, what is Exhibit 17A?
Exhibit 17A is an excerpt from the DSM-5 that defines schizophrenia.
How do psychiatrists determine when somebody is suffering from schizophrenia?
We compare the symptoms the person says they're experiencing with the criteria listed here under diagnosis. A person suffering from schizophrenia must experience at least 2 of the listed symptoms for at least 1 month.
Mr. Khan, could you please call out those listed symptoms for us? Did the defendant say he was suffering from any symptoms?
Yes. During his 2019 interview with Major Riley for the case, the defendant claimed that he was hearing voices, experiencing delusions, and experiencing what are called negative symptoms. Based on my review of the cases, the symptoms he claimed to have did not meet the criteria for a diagnosis of schizophrenia.
What do you mean?
Let me give you an example. Mr. Ray claimed that he heard voices saying that his wife was cheating on him. Major Riley describes these as auditory hallucinations. But this isn't what the DSM means by hallucinations. Auditory hallucinations are when people hear a voice outside themselves that they believe everyone else can hear. The voices Mr. Ray describes are like when we hear our own thoughts in our head. The voices Timothy Ray described are better characterized as anxious internal thoughts, not auditory hallucinations.
You also said the defendant reported suffering from delusions. Can you explain to us what delusions are?
Delusions are false beliefs that a person firmly holds, despite the fact that they're not based in reality at all.
Based on your review of the record, was there any evidence that the defendant was delusional?
Well, there was evidence that Mr. Ray reported feeling paranoid about his wife having an affair and leaving him. Major Riley also mentions that the defendant accused his primary doctor of speaking to his wife behind his back.
In your opinion, do those amount to delusional thoughts?
No. Mr. Ray's wife actually was having an affair, and like I mentioned, delusions are false beliefs that are not based in reality. Mr. Ray may have had paranoid thoughts and anxiety, but that's different from having delusions.
You also said the defendant reported negative symptoms. What are those?
Negative symptoms are symptoms of diminished emotional expression that take away from a person's ability to function. Dr. Riley categorizes Mr. Ray's reported loss of concentration, changes in sleep pattern, or an inability to manage emotions as examples of negative symptoms.
Is it your opinion that the defendant was not experiencing negative symptoms?
No, I believe that Mr. Ray may very well have been experiencing the things Dr. Riley described.
Doesn't that support a diagnosis of schizophrenia?
No. The negative symptoms associated with schizophrenia impair a person's ability to function in life. Mr. Ray shared custody of his son with his wife, held a job, and completed everyday tasks like taking his son to soccer practice. The trouble Mr. Ray was having was not surprising, given the fact that he'd recently discovered that his wife was having an affair.
Dr. LaGreca, I'd like to move on to the second part of your opinion, that the defendant was malingering or faking his symptoms. How do you determine when somebody is faking mental health symptoms?
The DSM provides 4 factors that psychiatrists should consider when trying to determine whether someone is malingering. I identified 2 of them in this case.
How many factors does somebody have to meet in order for you to conclude that they're malingering?
When evaluating for malingering, we're not looking for a specific number of factors. The focus, rather, is on whether, after evaluating these factors, the physician conducting the evaluation concludes that the person is likely making up their symptoms or exaggerating their severity.
What was the first factor you found in this case?
Whether the medical evaluation took place in a legal context.
Why is that important?
Because Mr. Ray was being evaluated after being charged with murdering his son. Studies show that 1 in every 5 people interviewed in the context of a criminal investigation are malingering. Given his charges, Mr. Ray had significant incentive to exaggerate symptoms and even fake them outright.
You said you found 2 factors in this case. What was the second factor?
Whether there were discrepancies between Mr. Ray's claimed symptoms and the objective observation of those symptoms.
How does that factor into your opinion?
I reviewed information from 4 different doctor visits for Mr. Ray prior to his arrest and compared them to the information he reported to Major Riley in 2019. I found major inconsistencies between the symptoms he reported before and after his arrest.
What major inconsistencies did you find?
In the visits between 2010 and 2017, Mr. Ray reported anxiety, some trouble sleeping, and depression. He also reported that his wife believed he was having mood swings. Not once did he report any hallucinations. After his arrest in 2018, however, he claimed that he had actually had a history of hallucinations that went all the way back to childhood.
Why is that significant?
Because there's no independent information to support his claim. Mr. Ray's wife, father, and employer never saw any signs that Mr. Ray had been hearing voices or seeing things before he killed Nathan.
No further questions at this time, Your Honor.
Thank you, counsel. Cross-examination.
Yes, Your Honor. May I proceed?
Yes, you may.
Doctor, you'd agree that if you make incorrect assumptions, your opinion could be flawed, right?
Sure.
People who have severe mental illnesses, like schizophrenia, often grow up experiencing childhood trauma.
Can you repeat your question?
Sure. People with severe mental illnesses like schizophrenia also often grow up experiencing childhood trauma. Isn't that true?
I don't believe that that's a published statistic.
Doctor, is it your testimony today that childhood trauma is not a known cause of schizophrenia?
Yes, that is not a known cause. I think that you've mischaracterized what I've said, which is that a childhood of trauma can be an exacerbating factor. It is, however, not a contributing factor.
Doctor, you wrote a report in this case, didn't you?
Yes, I did.
Doctor, I'd like to turn your attention to page 74. This is in your report. Are you there?
Yes, turning my page to 74.
Read along silently as I read this aloud. Quote, childhood trauma makes a person more likely to develop severe mental illness.
Yes.
Those are your words.
Yes, but not schizophrenia. I'd like to clarify that childhood trauma is an exacerbating factor. It's not a contributing factor to schizophrenia. So it can increase the severity of a mental illness if someone has a mental illness, but it does not increase the likelihood of a rare mental illness like schizophrenia, which affects less than 1% of the world's population. And if childhood trauma were indeed to increase the risk of an individual developing schizophrenia, we would expect to see a much higher prevalence of schizophrenia. However, as it stands, schizophrenia affects less than 1% of the world's population.
Doctor, but you assumed that Mr. Ray's childhood trauma was not significant at all, didn't you?
I wouldn't say that I assumed that it was not significant.
Well, it didn't play into your evaluation, did it?
It's something that I always consider.
But you decided in this case that it wasn't significant even though Mr. Ray's mother abused him as a child.
I'm not sure what you mean by not significant.
Doctor, you didn't give any weight to the fact that Mr. Ray experienced significant childhood trauma and that may lead into his severe mental illness, did you?
I wouldn't say that I didn't give significant weight to that. I'm just saying that childhood trauma is an exacerbating factor, but not a contributing factor to schizophrenia.
Doctor, moving on. You also assumed that Mr. Ray's family history doesn't support a diagnosis of schizophrenia. We can agree on that, right?
Yes.
You know that a family history of severe mental illness makes someone more likely to develop a mental illness.
That is absolutely correct, yes.
Mr. Ray's mother suffered from severe mood swings.
Yes.
Severe enough that she was committed to an institution.
Yes.
And doctor, you'd agree that anxiety disorders experienced as a young man can worsen and even lead to a more serious mental illness, such as schizophrenia.
That is incorrect.
Doctor, again, you wrote a report in this case.
Yes, I did write a report in this case.
I'm going to turn your attention to page 72, section A, paragraph 1. Let me know when you're there.
Yes.
In your words, doctor, it is true that anxiety disorder experienced as a young man can worsen and even lead to a more serious mental illness, such as schizophrenia. Did I read that correctly?
Can you read that again to me? Sorry, you said page 72.
Yes, doctor. Page 72.
And sorry, which paragraph was it?
Section A, paragraph 1.
Section A, paragraph 1. Okay.
The last sentence. It is true that anxiety disorder experienced as a young man can worsen and even lead to a more serious mental illness, such as schizophrenia. I read that right, doctor?
Yes, you did read that correctly.
You assumed that that wasn't the case here.
Yes, I did. I definitely assumed that that was not the case.
Doctor, in fact, on direct examination, you said that it's your opinion that Mr. Ray wasn't suffering from any mental disorder at all.
At the time, I said that he was not suffering from a severe mental illness at the time that he killed Nathan Ray.
Doctor, on direct examination, you said any mental disorder at all.
Sure.
Mr. Ray has a documented history of anxiety and depression.
Yes, he does.
Anxiety and depression severe enough to cause him to be medically discharged from his service in the military.
Yes, he was diagnosed with generalized anxiety disorder by Dr. Riley in the year 2010.
And that anxiety and depression were severe enough that he was medically discharged from his service in the military.
That is correct.
Now, doctor, if a doctor were to ignore facts such as the timing of when certain events happened, the doctor's conclusion might be incorrect. Isn't that true?
Absolutely.
You told these jurors on direct examination that Mr. Ray was not having delusions because his wife did in fact have an affair.
Yes, that's correct.
But Dr. Jessica Ray's affair started in 2018.
Yes, that's correct.
Doctor, Mr. Ray reported hearing voices telling him that his wife was, quote, screwing around on him all the way back in 2015.
Yes, and I believe that he was malingering.
Regardless of what you think, doctor, he said those words, didn't he?
Yes, and he's had actually marital issues as early as 2014.
Doctor, in that same year, he said he feared that his wife and son would, quote, cut him up with a knife and leave him.
Yes.
You mentioned none of that on direct examination.
No, I did not mention that.
And doctor, we've already been to we know that you wrote a report in this case. It's not in there either.
No. I believe that he was malingering.
Doctor, you also ignored key portions of Dr. Giuseppe's sworn testimony about Mr. Ray.
I didn't ignore anything.
Well, Dr. Giuseppe evaluated Mr. Ray in 2017 before Jessica Ray had an affair.
Yes.
During that 2017 appointment, she pointed out that Mr. Ray looked terrible,
Yes.
that he looked like he hadn't showered in weeks.
Yes.
He accused his doctor of listening in on his phone calls.
Yes. He actually said this after Dr. Giuseppe asked whether or not he would potentially hurt his wife or his son. And he said that out of defensiveness.
Doctor, returning to my question, he accused his doctor of listening in on his phone calls.
Yes.
He accused his doctor of siding with his wife and conspiring against him.
Yes. This again was after she asked him if he would potentially hurt his wife or son.
Dr. Giuseppe refers patients to mental health professionals when she believes that their symptoms are serious.
Yes.
Based on his symptoms, Mr. Ray was referred to a psychiatrist.
Yes. And she actually never even bothered to follow up with her.
But Dr. Giuseppe wanted Mr. Ray seen the very next day by that psychiatrist, didn't she?
Yes. The psychiatrist was actually her close friend, Dr. Erin Hall.
You didn't mention that Dr. Giuseppe wanted him seen the next day on direct examination, did you?
No.
And we can agree that the referral to a psychiatrist is nowhere in your report.
No.
By the way, doctor, you wrote this report based on reading 100 pages of documents.
Yes, that's correct.
That took you 25 hours.
Yes, that's correct.
And you said that you charged your standard rate, $500 an hour.
Yes, that is correct.
So for reading 100 pages and writing a 7-page report, you billed $12,500, didn't you?
Yes, that is correct.
On direct examination, doctor, you didn't tell the jury any of the statements made by Nathan's mother in this case, did you?
I'm sorry, can you tell me what statements you're referring to?
Sure. Well, first, doctor, they don't appear anywhere in your report, do you? Do they?
No.
So the truth of it, though, is because Jessica Ray reported that Mr. Ray had mood swings all throughout their relationship.
Yes. That actually led to the marital issues and his wife threatening to leave him as early as 2014.
Doctor, returning to my question, Mr. Ray had mood swings all throughout their relationship, yes or no?
Yes.
He would lock himself in the bathroom for hours.
This was actually at some point towards the tail end of their marriage when Jessica Ray was having an affair with the neighbor.
Doctor, returning to my question, Mr. Ray would lock himself in the bathroom for hours.
Yes, again, at the tail end of their relationship.
Wouldn't shower for more than a week at a time.
Yes, also coincides with the months leading up to October 17th, 2018, when Jessica Ray was having an affair.
Doctor, you spoke on direct examination about how you went to medical school, you had a residency. Throughout all of that education, I'm sure you've learned how to answer a yes or no question, right?
Yes. I'm also trying to give
moving forward.
some of the questions that you're asking me as well.
Doctor, as soon as she heard that her son had been killed, Jessica Ray told the police, quote, "I knew I should have never left Nathan alone with him when he was acting strange."
Yes, as you mentioned earlier, he had been acting really odd after he found out that she was having an affair, locking himself in the bathroom and being more isolated, as you mentioned.
And doctor, you never mentioned her words, quote, "I knew he was going crazy."
No, that was already in the case materials.
But it's not in your report,
No,
and you didn't mention it on direct examination.
no.
No further questions.
Thank you, counsel. Any redirect?
Yes, Your Honor, briefly. Turning your attention to Major Riley, how many times did Major Riley medically evaluate the defendant?
Twice. Once in 2010 and then again in 2019 for this case.
During which of those visits did Dr. Riley diagnose the defendant with schizophrenia?
During the 2019 interview with the defendant after he had been arrested.
No further questions, Your Honor. May this witness be excused?
Yes, she may. Thank you, Dr. LaGreca. State, do you have any other evidence you'd like to present at this time?
No, with that, Your Honor, the state rests.
Defense, do you have any motions you'd like to bring?
Your Honor, because we have our own burden today, we will be bringing no mid-trial motion.
Understood. All right, so before we proceed to defense case in chief, let's take a 5-minute recess. Here where I live, for me, that would be, we return at 11:23. So do the math and figure out what that means for you. But I will see you then. Would you all like a time check at the time that we return?
Yes, please, Your Honor.
Okay, so timekeepers, please take this time to confer with each other. And then when we come back at 23, please let us know the time for each side. All right, counsel, so are all the necessary parties here? All right, and I think we're just waiting on Miss Ariola. And my apologies if I'm mispronouncing that. Like I gave you guys grief about my last name, and then here I go butchering other people's. So,
No worries, Your Honor, I'm here.
okay. Oh, perfect. Wonderful. So I don't know if you guys were able to confirm with your timekeepers, or if the timekeepers want to come on, just unmute their audio and just let us know the time remaining for each side.
Your Honor, the timekeepers have sent in the times to the chat.
Ah, perfect. Wonderful. All right. So defense, you may call your first witness.
Would you mind if we just had those times read on the record? Thank you so
Of
much.
course. There is 28 minutes and 8 seconds remaining for the prosecution. There are 30 minutes and 49 seconds remaining for the defense. So defense, please call your first witness when you are ready.
My apologies, I forgot to unmute myself. The defense calls Dr. Riley to the stand. Permission to proceed, Your Honor?
Yes, you may.
What do you do for a living, Dr. Riley?
I own my own military forensic psychiatry practice, providing psychiatric services to veterans who are parties in legal matters.
In June of 2019, I asked you to make an independent analysis to tell if Mr. Ray was suffering from a severe mental illness on the day his son died. Were you able to reach a conclusion?
Yes,
How long have you been a psychiatrist?
22 years now.
And besides medical school, what specialized trainings have you received in psychiatry?
I did both my residency and my one-year fellowship in forensic psychiatry at Walter Reed Medical Center.
Did you practice psychiatry in the military?
Yes, I did. I served as a psychiatrist while deployed in Iraq. Later, I was on clinical assignment at Walter Reed, in charge of the psychiatric inpatient unit. While there, I treated hundreds of military personnel suffering from mental illnesses, including schizophrenia.
What does it mean to be board certified in forensic psychiatry?
It's an acknowledgement of an individual's competence in the field of medicine.
And doctor, are you board certified?
I am.
Have you published articles about the treatment of mental illnesses, including schizophrenia?
Yes, 15 peer-reviewed articles, a majority of which were about forensic psychiatry, 2 specifically dedicated about schizophrenia.
Your Honor, I offer Dr. Riley as an expert in the field of forensic psychiatry.
Any objection?
No objections, Your Honor.
All right, so Dr. Riley will be tendered as an expert in the field of forensic psychiatry. You may proceed, counsel.
Dr. Riley, at the time of his son's death, was Mr. Ray suffering from a severe mental illness?
Yes, Mr. Ray suffers from severe schizophrenia as well as anxiety and depression.
And what happens when a person has all those conditions at once?
The anxiety disorder and depression, especially when untreated, can exacerbate the symptoms of severe schizophrenia.
Are those findings, and all the findings you're going to tell the jury today, ones that you reached with a reasonable degree of medical and psychiatric certainty?
Yes.
Doctor, the jury has heard that you first met Mr. Ray in the military in 2010. How did he end up seeing you?
So his commanding officer at the time reported that Mr. Ray had been seeing things, was sleepwalking, and said that Mr. Ray reported feelings of depression, that he wished he were dead. After my examination of him, I diagnosed him with generalized anxiety disorder, and he thereby was medically discharged from the military.
Doctor, I'd like to take you back to 2019. When I hired you, I provided you with every document relevant to this case, police reports, medical information, witness statements. Did you review all that information?
I did.
Did you speak with anyone from Mr. Ray's life?
Yes, I spoke to his father, his former boss, and his ex-wife, Jessica Ray.
And what about Mr. Ray?
I interviewed him for 3 hours.
What was he like in that interview?
He was fine for the most part, but at times he seemed to lose touch with reality. At one point he became combative, accused me of being a government agent, said that I was out to get him, and also said that there was a camera in my microwave.
Were there any other significant behaviors you noted?
Yes, he seemed disjointed at times. We had to stop the interview 3 times, once because of his paranoia, twice because he began to cry hysterically.
What did Mr. Ray share with you about the day his son died?
He said he was already feeling anxious about work that morning, and his son then spilled juice on his laptop, amplifying his anxiety.
How did Mr. Ray react?
He said the voices told him his son did it on purpose to sabotage him. So as punishment, he forced him to do jumping jacks, high knees, and to run in place to remove this evil from him.
And what did Mr. Ray say happened next?
He said his son wasn't listening, which had made him mad. Mr. Ray said he went to his bedroom to calm down, but that didn't work. He then heard a creepy voice that told him he should kill his son for acting out. So Mr. Ray said he went back into Nathan's bedroom and strangled him with the belt.
Doctor, the jury has heard that childhood trauma and genetics are often associated with schizophrenia. Was there childhood trauma?
Yes. So Mr. Ray's mother would force him to take baths in cold water and often would refuse to feed him and eventually left them at 3 years old.
And in terms of genetics, was there any indication that mental illness ran in his family?
Yes. The mother was institutionalized with symptoms resembling schizophrenia when he was 6. But
Hold
Not
on,
actually, Your
counsel.
Honor.
Yeah, we need a sidebar now.
Yes, Your Honor.
So this witness just testified that the mother's symptoms, it seems like she's making a correlation to the mother's symptoms to schizophrenia. And my ruling in motion in limine was that this expert would not be able to testify regarding what that mental illness might be. So I'm curious as to why this witness is giving that testimony.
Yes, Your Honor. I thought the pretrial ruling was to make no formal diagnosis. My apologies. I'm happy to instruct the witness not to give the resemblance comment. My apologies, Your Honor. I misunderstood the
Motion to strike.
Yeah, please.
Sorry, prosecution, what was that?
Motion to strike the witness's answer, Your Honor.
Yes, that testimony will be stricken. I'm going to instruct the jurors to please disregard that last statement made by Dr. Riley. And you may continue, counsel.
Yes, Your Honor. Dr. Riley, was Mr. Ray's mother institutionalized without commenting on symptoms or any other illness, please?
Yes, she was.
Do we know about when?
So she was institutionalized 3 years after she left him, so at age 6.
Did Mr. Ray ever report hearing voices in his early life?
Yeah, soon after that, he reported that he started hearing voices at the age of 10.
Dr. Riley, the jury has already heard about the DSM-5. Dr. Riley, on Exhibit 17A, which is found in your electronic notebook, shares the criteria for diagnosing schizophrenia. Can you share with us those criteria?
Yes, to diagnose an individual needs 2 or more of the DSM-5 symptoms for at least 1 month or a longer period of time, as said earlier. In addition to having 2 or more of these symptoms, an individual also has to show impairment in one of the major areas of functioning, of which include interpersonal relations, self-care, for a significant period of time since the onset of the disturbance. And finally, the third prong of this diagnosis is that cannot be caused by effects of a substance or another medical condition.
Did you follow the DSM-5 when diagnosing Mr. Ray?
I did.
I'd like to talk about that third criterion first. Was there any evidence Mr. Ray's behavior was explained by effects of a substance or any other medical condition?
No, there was no evidence he was experiencing the effects of a substance and had no past medical history to suggest a medical condition.
Your Honor, permission to publish to the screen a demonstrative. It has been shared with opposing counsel pre-trial.
Prosecution, do you have any objection to their demonstrative?
No objections, Your Honor.
All right, then counsel, you may publish as you see fit.
Dr. Riley, we're pulling up the DSM-5 symptoms for schizophrenia. Which, if any, of these symptoms was Mr. Ray suffering from?
He was suffering from delusions in the form of paranoia, auditory and visual hallucinations, and an inability to control emotions, also known as negative symptoms.
What shows Mr. Ray was suffering from delusions?
His paranoia. I witnessed it firsthand when he told me that there was a camera in my microwave and that he thought I was a government agent, but also he expressed extreme paranoia to Officer Wentz when he was stopped at the sobriety check, saying the CIA was watching him.
Was he suffering from delusions before his arrest?
He was. Mr. Ray reported being paranoid in 2015, stated that his wife and son were conspiring to cut him up with a knife and leave him, also reported by Dr. Giuseppe.
What about hallucinations?
Hallucinations are, so just to give context, hallucinations are when people see, hear, feel, or smell things that aren't there. So hearing voices is a form of auditory hallucinations. Mr. Ray was hearing voices starting when he was 10 years old. His superior officer reported in 2010 that Mr. Ray had been seeing things. And he also, in 2015, told me things got worse. He then started hearing these male voices telling him his wife was cheating on him with their neighbor.
What about visual hallucinations?
He did. Mr. Ray indicated that he started having visual hallucinations, including triangles on the wall, which changed shapes and colors as early as 2017.
And how did Mr. Ray show signs of negative symptoms?
He demonstrated several signs, actually. His social phobia, as he isolated himself in the bathroom, his lack of personal hygiene on multiple accounts, and his inability to control his emotions, evidenced by his crying outburst.
Were you able to independently corroborate his symptoms with other people?
I was. I spoke with his boss, his father, and his ex-wife, who confirmed these symptoms. I also read his physician's findings.
What did you learn from the physician that was significant?
From the physician, Mr. Ray's physician had saw him on several occasions. So in 2017, his symptoms were severe enough that she referred him to psychiatrist the very next day. Not to mention, she also said that he looked unkempt and hadn't showered for weeks.
What did Mr. Ray's ex-wife share with you about their married life?
Jessica had stated her ex-husband had issues with mood swings and would feel okay one minute and the next he couldn't stop crying. Also, towards the tail end of their marriage, Mr. Ray became more isolated. He would lock himself in the bathroom for hours and refuse to come out. And she also told him she was filing for a divorce a few days before Nathan's death.
Did she tell you about his hygiene?
She did. She shared that Mr. Ray would go over a week without showering.
What about the months leading up to Nathan's death? How did Jessica Ray describe her ex-husband?
She told me that Mr. Ray had turned into a completely different person before she even had her affair, and often pleaded with him to get help, like a psychiatrist or something. And she also told Detective Booth that she knew he was going crazy.
Was all of this information sufficient for you to conclude that Mr. Ray suffers from schizophrenia?
Yes, the DSM-5 requires, again, 2 symptoms out of these 5 to diagnose schizophrenia, and he suffered from at least 3, all for more than a month before his arrest.
Thank you. Doctor, the prosecution talked today about malingering. What is your opinion on malingering?
There's always a possibility that a patient is malingering or making up their symptoms to create a legal defense. But so many independent sources confirmed symptoms before Nathan's death that, for example, his father, his boss, his commanding officer, and most notably, Mr. Ray's ex-wife, Nathan's own mother.
Why were the wife's comments most notable?
Because of the timing. Remember, a diagnosis of schizophrenia depends on demonstrating symptoms for a month or longer. Mr. Ray's ex-wife confirms these symptoms of schizophrenia for over a month, possibly years before, all before Nathan's death.
Is there any treatment Mr. Ray has received since his arrest that is consistent with your diagnoses?
Yes, in prison, he was prescribed 300 milligrams of Seroquel.
And doctor, what is Seroquel?
Seroquel, otherwise known as quetiapine, is an antipsychotic used to treat certain medical conditions and mood conditions. It can be treated, Seroquel can be used to treat schizophrenia, bipolar disorder, and sudden episodes of mania or depression associated with bipolar disorder. And it can be used for any of those that I discussed.
Doctor, is schizophrenia a mental condition that can affect the ability to know right from wrong?
Yes, it can.
Can it keep some people from understanding the nature and quality of their acts?
Yes, it can totally distort their perception of reality.
Doctor, during your interview, did Mr. Ray acknowledge that what he did was wrong?
Never. I asked him if he thought killing his son was wrong, and he responded that he was in a better place now. I asked if he still would have done it if a police officer were watching him, and he said yes.
Thank you, Doctor. Nothing further, Your Honor.
Cross-examination.
Yes, Your Honor. Good afternoon, Major Riley. Major Riley, you're a military forensic psychiatrist.
That's correct, yes.
Your practice provides services to veterans who are parties in legal matters.
Yes, that's correct.
Like the defendant.
Yes.
But the defendant's status as a veteran isn't your only connection to him.
No, that's not.
He's a former patient of yours.
He is.
And that's one of the reasons why you decide to charge him less than your normal hourly rate.
So my hourly rate is for all veterans.
And that's the veteran discount is another reason why you charged him less than your normal hourly rate.
Yes.
And you actually reduced your fee to review his case, right?
Yes.
You hope that a favorable outcome in this case will provide awareness to the mental health burdens veterans carry.
A favorable outcome would provide awareness, but I would also love to spread awareness of mental health regardless.
So the answer to my question is yes?
Yes.
Now, you first met the defendant in 2010.
Yes, I did.
That's when you evaluated him for the first time.
I did.
He just completed basic training.
Mm-hmm.
But he'd been, I'm sorry, was that a yes?
Yes, that's yes, sorry.
But he'd been discharged shortly before you saw him.
Yes, he was medically discharged, correct.
Now, you performed a full psychiatric evaluation of the defendant at that time.
I did.
But he specifically denied having any hallucinations.
That's correct.
But your opinion today is that the defendant was suffering from visual hallucinations back in 2010?
Yes. A patient will report symptoms as they feel. I can only evaluate them what they tell me at the time.
And in 2010, you diagnosed the defendant with general anxiety disorder.
That's correct. Yep.
Not schizophrenia.
That's correct.
You also evaluated the defendant in 2019.
Yes.
1 year after he'd admitted to strangling his son to death.
Yes.
And this time, you were paid an expert consulting fee for your work.
I suppose, yes. That's my career now.
And during this evaluation, the defendant claimed he'd been hearing voices since he was 10 years old.
Yes.
Now, you interviewed the defendant's father as part of your work in this case.
I did.
He never said anything to you about the defendant hearing voices growing up, right?
He never said that, but I don't know if Timothy Ray ever endorsed to his father that he would ever hear voices as well.
Now, his father also never said that to you that the defendant was seeing things either.
He did not specifically say that, no.
You also interviewed the defendant's wife, Jessica Ray.
I did.
She never said anything to you about the defendant having hallucinations.
No, but schizophrenia can come in different waves of the 5 symptoms. So a combination of any of the 5 is part of the diagnosis. And she noticed a lot of what we call the negative symptoms, as well as the impairment on the life of an individual. And also the paranoia, of course.
You also interviewed the defendant's boss at work.
Yes, I did.
And he never said anything to you about the defendant hallucinating either.
No, he did not, but he endorsed that he saw crying outbursts weeks leading up to the event.
Now, as part of your preparation, you reviewed notes from when the defendant visited a doctor in jail.
I did, yes.
That visit was 1 month after your 2019 interview with the defendant.
That's correct.
Mr. Ray actually asked for that interview.
He did.
He told that doctor he was feeling depressed,
Yes.
anxious,
Yes.
and in a constant state of worry.
Yes.
Now, we can admit that those feelings aren't surprising for somebody facing a murder charge, right?
Possibly, but he also had all these underlying mental illnesses as well.
But there's no indication that he told that doctor that he was seeing things.
Not at that time, no.
There's no indication that he told that doctor he was hearing voices.
No.
There's no indication that he told that doctor that he was having any hallucinations.
He did not. It's not in the report. You're correct about that.
Now, on direct, you mentioned that that doctor prescribed him Seroquel,
Yes, that's correct.
which can be used to treat schizophrenia,
Yes.
but it can also be used to treat other mental conditions.
Yes. So again, it's bipolar disorder and mania and depression associated with bipolar disorder, which also requires a lengthy diagnosis. It's also a lengthy evaluation as well.
But the jail doctor's notes indicate that they made no formal diagnosis of Mr. Ray at the time.
That's correct.
You also believe the defendant was suffering from delusions leading up to the time he killed Nathan.
Yes.
You say that his paranoia about his wife having an affair constitutes a delusion?
No, it's a distortion of reality, a fixed firm belief. And the affair occurred in later on after he started endorsing these paranoid symptoms back as early as 2014, 2015 with Dr. Giuseppe.
I'm sorry, Major Riley. My question was, is it your opinion that his paranoia about his wife having an affair constitutes a delusion?
Yes.
You say that he expressed that paranoia in 2017
Yes.
to Dr. Giuseppe.
Yes.
When you interviewed him for this case, the defendant claimed he'd been having those thoughts since 2015.
That's correct.
But no one else told you that the defendant expressed any concern about that in 2015.
At that time, no one else had seen him as a provider.
But nonetheless, Mrs. Ray actually admitted to you that she was having an affair.
She did.
And you read in Dr. Giuseppe's testimony that the defendant's wife was threatening to leave him as far back as 2014.
Yes.
You also believe that the defendant was exhibiting extreme paranoia on the night he was stopped of October 19th.
Yes.
Because he claimed the CIA was following him.
Not just that, he actually had a period of catatonic behavior as well. He endorsed to Officer Wentz, I believe, who described it, which can also be a period of worsening schizophrenia or a schizophrenic episode. That's actually one of the major, it's one of the major kind of indications for schizophrenia.
But you admit that there's a possibility the defendant is malingering.
There is. I did say that there is always a possibility in this case, but as I said, he demonstrated multiple symptoms of schizophrenia corroborated by multiple people, and that in itself gives him a diagnosis that excludes malingering.
Now, just to be clear for the jury, malingering can mean exaggerating your symptoms?
It can, yes.
Or making them up altogether?
Yes, but no normal layperson can really make up schizophrenic symptoms.
Now, you also admit that there is a much higher likelihood of faking symptoms when facing a murder charge.
Yes, I did say that in my report.
And the defendant had killed his son just 2 days before He told the police the CIA was following him.
Yes.
Thank you. No further questions, Your Honor.
Thank you, counsel. Any redirect?
No redirect, Your Honor.
All right, Dr. Riley, you are excused. Thank you. Defense, call your next witness.
The defense calls Officer Peyton Wentz to the stand. May I proceed, Your Honor?
Yes, you may.
Officer, where are you employed?
I'm a patrol officer with the Skelton Police Department.
The jury has heard that Mr. Ray was stopped by you at a DUI checkpoint on October 19th, 2018. Was he stopped for being drunk?
No, he was not.
Was he acting drunk?
No, ma'am.
If he wasn't acting drunk, what concerned you?
The moment I started talking to him, I could just tell something was off.
When you say off, how did he look?
Well, he looked kind of completely disheveled. His hair was a mess. His eyes were glassy. Right away, I could smell this overwhelming body odor. It looked as if he'd been in his car for a few days.
How did the interior of his car look?
It was a mess. There was trash everywhere.
And in the first moments of your interaction, how is Mr. Ray acting?
Just off. I mean, he got really antsy when I asked him for his license and registration, and he asked why I needed them.
Did he give you his license and registration?
Well, eventually, but he needed some convincing.
What happened once Mr. Ray gave you his license and registration?
Well, as soon as I had his license and registration, I walked away to go run his plates. And then when I came back, he started asking me if I was in the CIA.
How did you respond to that?
I told him, no, I'm with the Skelton Police Department, but he didn't seem to really hear my response, and he kind of just kept talking.
Was anything more said about the CIA?
Yeah, he said he knew the CIA had been watching him because according to him, they thought he was a terrorist. He seemed totally paranoid. He said he could even hear the sirens of the CIA coming to get him.
Were there any sirens going off nearby?
No, there were not.
Was this the last time that Mr. Ray brought up the CIA?
No, he brought it up again when I tried to get him to step out of his vehicle. He just kept asking for my CIA credentials.
When you asked him to step out of the vehicle, did he comply?
Not at first. You know, I mean, I kept showing him my badge and telling him I work for Skelton PD, not the CIA. After I told him that, he got out of his car.
Once he was out of the car, how did Mr. Ray behave?
Well, then his behavior changed. He said kind of all of a sudden started acting like a zombie.
What do you mean by that?
He was moving really slowly. He had this blank stare on his face. He wouldn't make eye contact with me.
Was he saying anything?
Yes. He kept saying, I didn't mean to. I'm a good father. He started explaining that he was just trying to get his son in shape to admit what he broke. He said his son needed to do jumping jacks.
How did his voice sound?
He kept talking in this really sort of low monotone voice.
Were those responses to questions that you were asking?
No, it didn't really seem like he was talking to me. It kind of seemed like maybe he was talking to himself, or I don't know, maybe nobody at all.
After he said that his son needed to do jumping jacks, what did he do?
Well, then he started to do jumping jacks.
You mean that on the side of the road, Mr. Ray started doing jumping jacks like we were taught to do in gym class?
Yeah, I mean, I told him to stand still, but he just ignored me. It was like he didn't even hear me.
When did that stop?
Well, you know, eventually I pulled out my gun and I told him to stop.
Was that successful?
Kind of, except he stopped doing jumping jacks and then he started moving his head uncontrollably. He was like holding his hand over his ears like this and kind of doing this type of motion. He started rambling to himself in this quiet, frenzied voice.
After hearing and seeing this behavior, did you radio police headquarters about Mr. Ray?
Yes, that's when Detective Booth was sent to the traffic stop.
Did you tell Detective Booth about what you had observed?
I did. I told him everything I just said. Something seemed off, that Mr. Ray had a body odor. I looked disheveled. You know, I was surprised they didn't send an EMT. You know, I thought that this guy might need medical attention.
Action relevance.
Response.
Your Honor, this witness just testified that he believed that Mr. Ray needed medical attention on the night of his arrest. This is directly relevant to his mental state at the time that Nathan Ray died. Also, this goes to show that Detective Booth was notified that Mr. Ray could have used medical attention that night and didn't follow through with getting that medical attention, and also didn't preserve the tapes so that everyone could see them today.
Any response from the state?
Yes, Your Honor. Officer Wentz is not a medical expert, and therefore his opinion as to whether medical attention was needed is not relevant. Also, this would mislead the jury because the ultimate issue in this case is a medical question. So if we have if we have Officer Wentz testifying that he indeed knows for a fact that this person needed medical attention, then that would mislead the jury into believing that this was a serious mental health crisis when Officer Wentz does not have that experience to back that up.
I believe officers are trained to determine whether or not a suspect or an individual they encounter would need medical attention. And so I do believe that he is allowed to give this testimony despite being a lay person. Furthermore, I do believe it is relevant as defense counsel stated. So I'm going to overrule your objection. You may proceed.
Detective Booth testified that you drove Mr. Ray to the police station. How did he behave when he was in your patrol car?
Well, he was calmer than he was before, but he was still crying and repeating the same things he was saying earlier, over and over again.
What do you remember him saying?
I just kept repeating things like I messed up, that he didn't mean to do it, and that he was a good father.
Throughout the night of his arrest, was Mr. Ray ever seen by a doctor?
No.
Did you see anyone give him medical attention?
No, I did not.
Officer, you've worked DUI checkpoints before. Is that true?
Yeah. Yes, I have.
Have you ever seen anything like Mr. Ray's behavior in any of your traffic stops?
No, I have not.
No further questions.
Thank you, counsel. Cross-examination.
Yes, Your Honor. Officer, once you were working a sobriety checkpoint the night the defendant was arrested.
Yes, that's correct.
When he drove up to the checkpoint, you went to his car.
Correct.
And asked to see his license and registration.
Yes.
At first, the defendant refused to give those to you.
Yes, that's correct.
At first, he said he didn't have his license and registration on him.
Yes.
But you could see that his wallet was on the center console of the car right next to him.
Exactly, that's correct. It was kind of weird.
And you pointed that out to the defendant?
I did.
And that's when he handed you his license and registration?
Yes.
Once the defendant handed you those license and registration, you gave those to your partner?
You're correct.
And you decided to return to Mr. Ray's vehicle?
Yes.
Because you wanted to keep an eye on him?
Yes, I did.
You then ordered him out of the car?
Yes.
Because you were suspicious of him?
That's correct. Yes, something seemed off.
The defendant followed your order and got out of the vehicle?
Eventually, again. I had to do some convincing, but eventually he did.
After you were able to convince him to get out of the car, you heard the defendant say, quote, "I'm a good father. I didn't mean it."
As I just said, yeah, he said all those things.
After you handcuffed the defendant, you heard him say, quote, "He's gone."
Yeah, that's one of the things that he said. Yeah.
Now, you didn't know who the defendant was talking about.
No, at that time, no.
But you had learned that the defendant's son was missing.
Yes, once we ran the plate, or sorry, the license and registration, that's when we learned about the missing persons case.
And in fact, you could see a child's booster seat on the back seat of the defendant's car.
Yes, I could.
Right next to the shovel.
Correct.
After Detective Booth got there, you and your partner drove the defendant to the police station.
Yes, we did.
And on that drive, the defendant was crying?
Yes.
And you could hear him say, quote, "I messed up."
Once again, yes, he said that during the police ride over to the station.
The defendant also said he didn't mean to do it.
Once again, yes, that's one of the things he said.
No further questions, Your Honor.
Thank you, counsel. Any redirect?
No redirect, Your Honor.
All right, well, thank you, Officer Wentz. You are excused.
Thank you.
Does the defense have any other evidence they wish to present at this time?
Not at this time. The defense is ready for closing arguments. We just ask for a time check before we move into those.
Yes, actually, let's take a 5-minute recess. Let's return at 12:03. And at that point, yes, pop it in the chat. Timekeeper is exactly how much time both the prosecution and the state have for summation. Prosecution, at this time, would you like to reserve any time for rebuttal?
Yes, Your Honor, I would like to reserve the remaining time for rebuttal.
Understood. All right, so let's return at 12:03. All right, do we have all the parties back? All right, perfect. So based on what was put in the chat, prosecution, you have 16 minutes and 50 seconds remaining for your summation, and defense, you have 12 minutes and 29 seconds remaining for summation. Would either party like a countdown or to know whether they have a minute left or 10 seconds, or will you just proceed?
Yeah, Your Honor, that would be nice.
Yeah, a 1 minute warning would be nice.
All right, so timekeepers, I instruct you for your side. So if you're the prosecution timekeeper, give prosecution a 1 minute warning when they have that remaining, and same for defense timekeeper, give the defense a 1 minute warning. All right, now that we are ready to hear closing arguments from each party, everyone should please switch back to speaker view. And prosecution, you may begin when you are ready.
2 years ago this past Monday, Jessica Ray went to Skeleton Elementary School to pick up her 6-year-old son Nathan from school. She'd been calling her soon-to-be ex-husband since the night before, but he wasn't taking her calls. And she wasn't surprised. Things had been bad between the two of them since they separated earlier that year. But things changed when she spoke to Nathan's teacher. It turns out not only was he absent that day, he hadn't been in class the day before either. Miss Ray called the defendant again. No answer. She called again. No answer. Then she drove to the defendant's house to figure out what was going on, but he was gone. His car was gone. More importantly, Nathan was gone. Then she called the police, worried the defendant had run off with Nathan. She had no way of knowing. The truth was much, much worse. Like my co-counsel told you during our opening statement, we have the responsibility to prove that the defendant murdered his 6-year-old son, Nathan. We also promised you the defense would fail to meet their burden of proving that the defendant suffered from a mental disorder that excuses him from being responsible for his son's death. The evidence has done this by establishing 2 things. First, the defendant knowingly killed his son by strangling him to death. And second, the defendant understood that killing his son was wrong. Let's start by taking a look at the first point, that the defendant knowingly killed his son by strangling him to death. As Judge Adillo instructed you, in order to find the defendant guilty of murder, we have to prove that the defendant killed his son with malice aforethought. Now, that doesn't mean we have to prove he hated or had any ill will towards the boy. Malice aforethought means killing in a way that's callous, cruel, and with a complete disregard for human life. Members of the jury, a father using a belt to strangle his 6-year-old son with, that's about as callous and cruel as it gets. In order to understand why the defendant chose to end the life he helped create, we only need to look back to the moments right before the killing. Nathan was getting ready for school that morning, just like millions of kids across the country. He was in the kitchen eating his favorite cereal and drinking apple juice when he accidentally spilled the juice on his father's work laptop. Instead of understanding that dealing with spilled juice is just part of being a parent, the defendant started yelling and screaming at the 6-year-old boy. Nathan started crying, saying he wanted his mother. But that just made the defendant yell even more. So Nathan ran upstairs to his bedroom, his safe place. But the defendant followed. More yelling, more screaming, more of Nathan sobbing for his mother. And that had to be hard for the defendant. You see, it had only been a few months since he was able to confirm that his wife was cheating on him, something he'd suspected for years, and now they were separated. So hearing his son cry for her, well, that's just unacceptable. So he forced Nathan to do exercises, jumping jacks, running in place, high knees, anything to get the boy to stop crying for his mother. But that just made Nathan cry even harder. So the defendant decided he was going to beat the tears out of him. He went into his room and grabbed a belt and started spanking the 6-year-old boy. And when that didn't work, the defendant took the belt, he wrapped it around the little boy's neck, and he squeezed the screams and life out of him. And I want you to really think about what strangulation takes. It's not a quick death. It takes time. We've all held our breath to see how long we could do it, right? 5, 10, 20, 30 seconds. However long Nathan could hold his breath, the defendant had to squeeze longer than that. And he squeezed and squeezed and squeezed till he made sure his son would never be calling for his mother ever again. Now, those facts are really undisputed. They came from the defendant's own mouth. It's what he admits took place. And as hard as it is for us to accept, some parents make the choice to kill their children just like the defendant did. And everything the defendant has done since then has shown that he was fully aware that his decision to strangle his son was just unforgivable. And that brings me to my second point, that the defendant understood that killing his son was wrong. Since we know there's no reasonable doubt that the defendant is guilty of murder, the only other things left for you to consider is whether the defense has proven that the defendant suffered from a severe mental disease or disorder when he killed Nathan. And if so, whether they've proven that the mental disorder kept him from understanding what he was doing or kept him from understanding that it was wrong. Now, the defense claims that they've proven the defendant was suffering from severe schizophrenia on the very morning he killed Nathan. He'd never been diagnosed with schizophrenia up to that point, even though he had been evaluated by a psychiatrist. In the military, he was hospitalized and discharged due to general anxiety and depression, but no sign of the schizophrenia they claim has been developing since he was a young child. And members of the jury, as bad as the defendant's breakup with his wife had been, did you hear any evidence that she saw signs of the man she married, lived with, and shared a family with was suffering from a severe mental disorder? Sure, she asked him to see someone for his anxiety, but had there even been the slightest hint that he was severely mentally ill, that he was the slightest threat to Nathan's safety, wouldn't she have seen it? Wouldn't the defense have brought you some evidence that shows she saw the defendant as a risk and fought to keep him away from her son? They didn't bring that evidence because it just doesn't exist. So where does the schizophrenia diagnosis come from? Well, Dr. LaGreca, the expert forensic psychiatrist we brought you in this trial, explained it to you. The defendant is malingering or faking his symptoms, to put it simply. And why would someone do that? Well, in order to avoid facing things such as prison time. So let's take a look at how Dr. LaGreca reached that conclusion. The defendant is being evaluated in the context of a criminal case, which is one of the factors psychiatrists should look for when determining whether somebody is faking their symptoms. And like Dr. LaGreca told you, 20% of people evaluated in the context of a criminal case are diagnosed as malingering. And the defendant isn't a part of just any criminal case, no. He's on trial for murder of his son, with no other evidence to even suggest anybody else could have done it. So this context alone should give you reason to doubt the defense's claims. But that's not the only thing that shows the defendant is malingering, because his claimed symptoms just don't match with the rest of the evidence. The defendant claims he's been hearing voices since he was 10 and seeing things since he was in his early 20s. But the defendant never mentioned hearing voices until a year after he killed his son. And he specifically denied having any visual hallucinations when he met with Dr. Riley in 2010. And although his behavior with his personal doctor, Dr. Samantha DiGiuseppe, may have been bizarre, if he was dangerous, wouldn't she have done more? Especially if he was dangerous and refusing to seek treatment? And as for Officer Wentz's testimony about how the defendant appeared to be acting crazy at the checkpoint, well, it's not hard to believe that somebody about to be arrested for murdering their child would pretend they were mentally ill. Members of the jury, that's everything you need to conclude that the defense has failed to prove that the defendant was suffering from schizophrenia. But let's give the defendant every benefit of the doubt for just a minute and assume they did establish he was schizophrenic. That's still not enough. Like the judge instructed you, even if they prove he was schizophrenic, they still have to show that he was not able to understand what he was doing, or he was not able to understand that it was wrong. Now, an example of this would be like if the defendant strangled his son but thought he was fastening a seatbelt around the boy's waist, or if he truly believed that by putting the belt around the boy's neck and squeezing would somehow make Nathan healthier. But there's no doubt that the defendant knew exactly what he was doing. Remember these internet searches that were found on the defendant's phone? Why would the defendant look for ways to get rid of Nathan's body if he didn't understand that killing him was wrong? And what about the search for countries that don't extradite for murder? Members of the jury, that not only shows the defendant was thinking about fleeing the country, it shows he knew he'd committed murder. Well, clearly, the defendant learned something from these searches, because the night he was arrested, he was found with gallon bottles of bleach, just like he'd searched for on the internet. And as for his search about how to get rid of a body, well, we know he came up with a plan there when he tossed his boy's body in a shallow grave in Brandywine Park. Now, in a moment, the defense is going to have a chance to talk to you. And when they do, I want you to listen. Listen closely when they tell you the defendant didn't understand what he was doing when he strangled his son, even though he admitted that he did it in order to get the boy to stop crying. Pay attention when they tell you the defendant didn't know he'd done something horribly wrong by murdering that defenseless child, despite the fact that he tried to cover up his actions. And ask yourselves if it makes sense when they look you in the eye and try to convince you that they've proven that the defendant isn't legally responsible for murdering the one person he was supposed to love and protect. And when those explanations don't make sense, when they leave you with more questions than answers, then you'll know the only just verdict is one finding the defendant guilty of murder.
Thank you, counsel. The defense, you may proceed with closing argument when you're ready.
Yes, Your Honor, just 1 second to get set up.
Sure.
May I proceed?
Yes, you may.
Timothy Ray didn't wake up one morning and decide to kill his 6-year-old son. He's not the callous, cold-blooded murderer that the prosecution claims he is. He suffers from schizophrenia. Schizophrenia is a severe mental disease, and in Mr. Ray's case, one that's gone unnoticed, unchecked, and untreated for a very long time. And it's because of this that Nathan Ray is dead. Under the laws of this country, we don't hold people accountable for actions that are caused by severe mental diseases like schizophrenia. That's why today we raised an insanity defense. That means that as the defense, we had the burden to prove by clear and convincing evidence, which simply means that it was very probable that Timothy Ray suffered from a severe mental disease, and that because of that severe mental disease, he wasn't able to tell right from wrong when Nathan died. I'm going to spend the majority of my time today talking to you about the first prong of the insanity defense, that Timothy Ray suffered from a severe mental disease at the time that Nathan Ray died. He suffered from schizophrenia. Today, we asked Dr. Riley to apply the facts and circumstances of Mr. Ray's life to the science of psychiatry. And that's exactly what she did. Dr. Riley is an expert, a board-certified forensic psychiatrist. She met with Mr. Ray back when he was in the military. She treated him before. She met with him again and evaluated him again after his arrest. Dr. Riley was also the only expert in this case to interview people from all walks of Mr. Ray's life. She interviewed his boss, his father, his ex-wife. Based on all of these facts and all of these interviews, Dr. Riley was the only one to faithfully apply the DSM-5 and to properly diagnose Mr. Ray with schizophrenia. You heard 3 indisputable facts about mental illnesses today. First, that childhood trauma is a known cause of mental illnesses. Second, that a family history of severe mental illnesses is a known cause of severe mental illnesses like schizophrenia. And third, that anxiety disorders that start in a young man can worsen over time, eventually becoming severe mental diseases like schizophrenia. All 3 of these apply to Mr. Ray. His battle with mental illness started when he was just a child and worsened over time. His mother abused him. And then she abandoned her 3-year-old son not long before she was institutionalized for her illness. As he got older, Mr. Ray started to have severe mood swings. As a young adult, he started having hallucinations. He was diagnosed with anxiety and depression so severe that he was medically discharged from his service in the military. In 2015, Mr. Ray started having extreme paranoia. Extreme paranoia that his wife was cheating on him. Strange voices in his head telling him that his wife was, quote, screwing around on him. Voices that told him that his wife and son were going to, quote, cut him up with a knife and leave him. These voices got louder and louder in the months leading up to Nathan's death. All of this took a toll on Mr. Ray's daily functioning, manifesting as what the DSM calls negative symptoms. While the prosecution spent a lot of time talking about how there was no evidence that Jessica Ray was concerned about Mr. Ray's mental health, she reported that he would lock himself in the bathroom for hours, that he wouldn't shower for a week at a time. By 2017, his doctor reported that he looked terrible. Throughout 2018, he was seen crying in his cubicle on numerous occasions. By the time we get to the second factor of the DSM, it's clear that Mr. Ray's entire life had deteriorated. His wife had left him because of the way that he was acting. He couldn't even do simple tasks anymore to take care of himself, like take a shower. But the prosecution today presented you a testimony of Dr. LaGreca, who, as you heard, essentially cherry-picked the facts that aligned with the theory the government wanted to present you with. Their theory that Timothy Ray wasn't sick at all, that he was just malingering. To further that theory, Dr. LaGreca ignored facts. She ignored key dates. She ignored statements of witnesses, including Jessica Ray. She ignored the fact that Timothy Ray had a diagnosis of anxiety and depression starting all the way back in 2010. Members of the jury, you know that she was ignoring facts every step of the way. Again, the prosecution today tried to point out that Jessica Ray had never pointed out that Mr. Ray was struggling, that he was showing signs of mental illness. They left out what she said to police right after hearing that her son had been killed. Quote, "I never should have left Nathan with him when he was acting strange. I knew he was going crazy." The first time Dr. LaGreca acknowledged those facts was when I asked about it on cross-examination. Now, aside from presenting you with an expert who casts aside facts, the prosecution also failed to preserve key evidence in this case. Detective Booth, the lead investigator on this case, the biggest case of his career, couldn't have been bothered to preserve the audio and video from his interview with Timothy Ray on the night that he was arrested. By failing to preserve those tapes, Detective Booth effectively destroyed the only evidence that would have allowed everyone in this courtroom to know what Mr. Ray looked like, what he sounded like, how he was acting. Instead, the prosecution is expecting you to rely on Detective Booth's memory alone, the memory of the same detective that just 2 months after the incident couldn't remember that Mr. Ray had asked him not once, not twice, but 3 times if he was working for the CIA. Now, 2 years later, the prosecution wants you to rely on that man's memory alone as proof that Timothy Ray is sane? Dr. Riley gave you all the facts you need in this case. Prosecution spent a lot of time talking about the 2010 diagnosis, but members of the jury, the truth is that in those intervening years, Mr. Ray had gotten a lot worse. And Dr. Riley had more information. Schizophrenia is a complex disease. But in this case, the diagnosis is clear. Timothy Ray suffered from severe schizophrenia in October of 2018. Now, a lot of those same facts that prove the first prong of the insanity defense also prove the second, that Timothy Ray, because of his severe mental illness, couldn't tell right from wrong when Nathan died. I'm not going to repeat those facts again because you know them. But what I will repeat for you are Timothy Ray's own words on the night that he was arrested. Quote, "I just needed to make him understand." Quote, "I never would have done it if they hadn't told me to. They told me to do. They told me she tricked him." Mr. Ray didn't know if what he was doing was right or wrong. He was just listening to the voices that had been controlling his life for so long. The prosecution also wants you to believe that because Mr. Ray took steps to cover this up, that means that he knew right from wrong. But use your common sense. People who are really trying to cover up their tracks don't drive around with their son's dead body in the car for days. They don't forget to delete their internet history. They don't cruise up to the police at a DUI checkpoint with 2 bottles of bleach and a dirty shovel laying out in their backseat for anyone to see. That's what someone with a severe mental illness does. And that's why the fact that Timothy Ray was insane just makes sense. Because normal parents don't kill their 6-year-old sons over a glass of spilled juice. And they certainly don't say, as Timothy Ray said to Dr. Riley, that they would do it again if the police had been watching. The prosecution gets the last word in this case. That means that they have one last chance to give you answers to the important questions. There are easily a dozen unanswered questions in this case, but for now, I'll leave you with just 2. Ask the prosecution why you should trust Detective Booth when he failed to preserve those tapes from his interview with Mr. Ray and when his memory just simply can't be trusted. Ask the prosecution why they ignored Jessica Ray's statements and why they act like she was lying when she said that her ex-husband was going crazy. And if those answers don't come, or if they don't ring true, that's how you'll know that severe schizophrenia killed Nathan Ray. Unnoticed, unchecked, and untreated schizophrenia. And that's how you'll know that Timothy Ray is not guilty by reason of mental insanity. Thank you.
Thank you, counsel. Rebuttal?
Yes, Your Honor. Members of the jury, the defense just got up here and spent 12 minutes talking to you, and they weren't able to give good answers to any of the questions I asked. 12 minutes about them talking about anything and everything but what happened the day Nathan died. But as complicated as they want this all to seem, here's all you need to know. If the defendant was insane, he wouldn't have searched for this after using this to kill him. If the defendant didn't know his actions were wrong, he wouldn't have used these to do this with Nathan's body. Members of the jury, he wouldn't have done anything with the body. He would have just left it sitting in the house. Now, the defense just got up here and said the defendant went unnoticed, untreated, and unnoticed, unchecked, and untreated. But he was noticed and checked by Dr. Riley, their own expert they paid, by the way, and Dr. DiGiuseppe. And then he was treated for his anxiety and depression. They also mentioned that the defendant did a poor job hiding the evidence after he killed his son. Members of the jury, just because somebody does a poor job hiding evidence doesn't mean that they tried to cover up their actions. The defendant knew right from wrong when he yelled at his son for spilling his juice. He knew right from wrong when he hit his son with a belt, and when he strangled his son, and when he looked up how to get rid of a body, and as he dug a shallow grave and tossed the boy's body inside for dogs to find. And because of that, justice demands the defendant be found guilty of murder.
Thank you, counsel. So jurors, please complete your ballots at this time. I'll ask everyone to stay on until everyone has submitted their ballots. And then once I get confirmation from our bailiff that all ballots are submitted, we will then proceed to brief comments.
All right, we have all ballots. You can start.
Okay, great. Thank you, everyone. You guys are great. So I'll just have each juror give brief comments. Now, just only for the attorneys, because we do have 4 jurors and then myself. I do ask that you limit these comments. I think it's helpful for the advocates if you give a comment of praise and then some constructive criticism. So let's limit it to those 2 comments, okay? So let's start with, who do we have? Juror, oh, I don't see your names. Well, would any juror like to volunteer to go first? Oh, Juror Fuentes, let's start with you.
Okay, so hi, everybody. I'm Gabriel Fuentes. I'm a U.S. Magistrate Judge in Chicago. Congratulations, everybody. I think it was really a very strong presentation and preparation by everybody. By way of comments, I thought the Gohar's cross-examination of Riley was very effective because it was just very methodical. It wasn't histrionic. It focused on the best points. On the other hand, the closing and to some extent the opening argument, opening statements, I thought maybe focused a little bit too much on defense counsel. You see if they can look you in the eye. It made it a little personal. And then what happened was Carly got up there and looked at us right in the eye and kind of, I thought in the closing argument, kind of hit that one out of the park. By way of constructive criticism, I'm sorry I can't get to everybody, but Carly, when you ran into the highly argumentative witness, LaGreca, sometimes when you're getting those add-on answers, it's okay to just say, Dr. LaGreca, you'll have a moment in a minute on redirect examination to add more if you wish to add more. But would you agree today to just answer my questions? Would you do that? And a lot of times you're going to get a yes, and judges appreciate it, you controlling your own witness rather than looking to them. Finally, Mr. Carlson, on the Riley exam where you kind of went someplace you weren't supposed to go, I believe you did that inadvertently, but just be really, really careful with those pretrial rulings, because I've certainly seen matters where counsel inadvertently or whatever did stuff like that, and judges really went through the roof, and in some cases wrote opinions, put their names in the opinions. You violated my ruling, you prejudiced the trial. I don't think that's what you're doing. You've got to really, really, really be careful not to let that happen to protect yourself, if anything else. Finally, reasonable degree of medical certainty. Guys, that doesn't mean anything. It means different things to different people. It has no accepted meaning in a courtroom, and many scholars have now said there's no place for it in a courtroom. So don't use that term just because you've heard it 1,000 times. That was all I had. Everybody was great, and I'm sorry I didn't have comments for all of the performers, just not enough time.
Juror Nye, can you go next?
Sure. Congratulations to everybody. Obviously, it was a job well done. You guys were very prepared. I'm an assistant U.S. attorney in the District of New Jersey, so this is a case that I'm familiar, this type of case I'm familiar with, so I know how challenging it can be, just the fact pattern alone. As far as the prosecution, I thought both the opening and the summation had great emotion. It had continuity in your approach to both the opening and the summation, which I think is huge, especially when you have a different person giving the opening and the summation, which can be challenging to keep that continuity in front of the jurors. In terms of constructive criticism for the prosecution, you had a lot of exhibits that were used, certainly on your direct witnesses. I think it would have been more helpful if you had those exhibits published and then ask questions regarding those exhibits to the witness and use them a little more effectively. It seemed that it was just a reference to the exhibit and then publishing without a lot of follow-up. And sometimes as the prosecutor, like the exhibits, that's your best foot, because it's not just your words. Like you can use those exhibits to show that this happened in the past and have the witness really kind of expand on it. So that's what I would say in terms of constructive criticism there. As for the defense, it was clear you're very comfortable with the record. You were very quick to combat bad facts with other facts that you had that helped you, which was great. I thought your theme was really good, also carried through between the opening and the summation. One thing you guys both did really well was reference other testimony that the jurors had heard. So when you had your witness, you would occasionally say, the jurors heard from witness so-and-so that this happened. How can you essentially explain it in a different way? And I thought that was great, because it shows not only that you're paying attention, but you were ready for it, that there are going to be things that weren't going to look great for your case, but you were able to use your witnesses or your cross-examination to fix that going forward. So congratulations to everybody involved. I was very, very impressed.
Juror Tierney, can you go next, please?
Sure. Hi, and congratulations to everybody. This was a very fantastic round to watch. I saw some previous law school tournament remote modes in the past month, and I was most impressed with this round so far. My commentary, I'll make it very general, and it's practitioner focused. I'm a public defender. I've been a public defender in Minneapolis for the past 6 years. My big commentary would be to, since this is battle of the experts, this case really does come down to whether or not the jury likes your expert or the other person's expert. You need to focus on some area of evidence that in your view is not going to be successfully attacked by the end of the trial. You need to give the jury one big specific reason that they're going to agree with your expert or they're going to agree with your case. I know that mock trial themes can often seem gimmicky. They're not used nearly as much in the real world, but I think that a theme would have been helpful in this case. For the prosecution, I like themes that focus on one big piece of evidence that you know is going to survive challenge. And I think that would be the defendant's consciousness of guilt. The fact that he's covering up his tracks, which shows an awareness that what he's doing is wrong, which significantly undercuts any claim of insanity. I didn't really hear a theme in the opening statement. It came out later on in the trial that he covered up his tracks, but there wasn't any real big, like, ladies and gentlemen, this is what we need to pay attention to throughout this trial. Because if you do that, then we don't really need to care about all the nonsense between the two experts and whether they disagree with each other. It's a case involving really complex evidence. The jury is going to zone out. They're not going to understand a lot of the back and forth between the lawyers and the witnesses. And that's how you avoid that. You dance around the edges of the experts by attacking their credibility, but you really try not to engage with the actual substance of an expert. And I really like how this mock trial used quasi-real experts. They're medical students, but still they know what they're talking about. And I think all of you had moments where you tried to challenge the expert and it burned you because the expert knew exactly what you were talking about ahead of time and they flagged that they knew what they were talking about ahead of time. I think my favorite moment in the trial was during the impeachment of the prosecution's expert when you asked her, please go to this page. And she said, yep, page 72, I'm there. And that, I think all four of you should use that as a lesson, because if you get an expert like that in real life, what that should be telling you is run away and don't challenge this expert, because they are flagging for you that they know exactly what you're talking about. You may disagree with the expert's interpretation of the evidence, but the jury is going to agree with the expert unless they are just flagrantly wrong in their interpretation. So those are my two big comments. Boil something down to one big piece of evidence when we are working with experts, and tap dance around the experts. You can't directly engage head on with substance or you'll lose.
All right, juror Tara Dixon, can you please go next?
Hi, I thought it was fabulous. I've seen a lot of mock trials as well, and I thought this was really well done. I believe that all of the comments that I had flagged throughout the course of the mock trial have already been touched upon by the three other jurors. So I'm simply going to say I really enjoyed the use of the exhibits. I agree that you might want to try and have the exhibits out there a little longer. It was hard to read them as quickly as they were on, they were off. I really did, however, like that the defense carried through and said, hey, can we remove that photo of the boy? I thought that was great. That was a good pickup. However, later on, actually, I'm sorry, not however, later on, the prosecution actually continued to take those exhibits right down as if she was anticipating an objection that never actually came. So I am a plaintiff's personal injury medical malpractice attorney in Philadelphia. And I can tell you that experts are always going to be difficult to cross-examine. It's just the nature of a medical expert. You're very rarely going to run into a medical expert that just doesn't know anything at all about what they're supposed to say or do or isn't prepared. So that having been said, I think everybody did a really great job with their handling of the experts. In fact, with every aspect of this mock trial. So congratulations.
Yes, congratulations, everyone. Excellent, excellent job. Just a little background about me. I'm a civil rights attorney in Chicago, so I don't touch criminal stuff until the guy gets off and then he wants to sue. So I do get to actually look at some criminal files, but I'm not actually in criminal court. And I thought you all did an excellent job. You guys are clearly strong advocates. You will all have successful careers because you've demonstrated skills that I've witnessed attorneys who've been practicing for years can't do. So I think you guys are fantastic. Just a point of criticism. Listen, listen, listen. Listen to the judge, listen to the witnesses, listen to the other attorneys. I'm not trying to pile on you, Mr. Carlson, but when you actually mentioned symptoms of schizophrenia in the opening, and I was just waiting for an objection, and I didn't get one. And that's what I mean why you got to listen closely. Obviously, I caught it when I asked for that sidebar. But I also thought there were moments where we could have heard more objections. I heard argumentative questions. I heard leading questions on direct, and we just did not get those objections. So don't be afraid to jump out of your chair. Although I understand that's a skill that you really do hone over the course of your career. So it'll obviously come to you, but I still thought you guys did a great job. Just specifically, defense, Carly, with regard to your first impeachment, I thought you fumbled the ball a little. And you had a tough expert. She, like was already mentioned, she was ready. And so if you're going to impeach, just make sure when you confront that witness, you're going to use their exact language, their exact testimony, the exact wording in the report. That way there's no wiggling out of it, because you didn't. And I was expecting an objection to improper impeachment or not impeaching, and I didn't hear it. So it worked for you, but just keep that in mind. And just a point for prosecution for rebuttal. Carly left you with 2 questions. You should have got right up there and answered them. And I know you can because you demonstrated a mastery of the facts. So, if you move forward, take that into consideration. If they put questions on the table, answer them. Another thing for your rebuttal, I liked your use of the exhibits, but keep in mind, you said, well, then they showed you this, they didn't take into consideration that. For your record, when that, let's say that goes on appeal and the appellate lawyer's reading it, they have no idea what this and that is. So if you go forward and do that same rebuttal where you say, they didn't show you this, say what this is. They didn't show you this, those Google searches. They didn't do that, bury the bag, show you this where he buried the body. Just be specific, just for the record. But otherwise, excellent, excellent job. Congratulations to both teams.
Thank you all for your time today and for all your feedback. That was really helpful.
So now I think we're all done. Thank you, everyone. You can sign off Zoom, and I wish both teams the best of luck.
Thank you.
Thank you so much.
Hey, I guess you guys don't want your results.
I do.
I want to find out who won.
Should I have my team sign back on?
Why don't you guys all sign back on so I can tell you what happened?
Okay, great. I'll tell them to come back on.
Let me know when sufficient amount of people were in the room.
Get on the call. Gohar, is everyone here from, oh,
Will you guys just let me know once all of your teammates are in the room and ready to go?
the defense is all here.
Okay. And prosecution is or I see this one of your teammates is in the waiting room here. Prosecution, you just let me know when everyone that needs to be here is here.
There she is. We're all here now.
Okay.
Oh, sorry.
Everyone is here?
Yes, sorry, I could not get that password. Thank you.
No worries. Congratulations to all of you. Congratulations on being in our semifinal round and being our division winners this year. Really, really great round. And congratulations to you and congratulations to your coaches as well. You guys were two incredibly dominant teams. Of the 18 ballots that you guys had in your preliminary rounds, you guys won 14 of those 18 ballots. And so this was the clash of the Titans. Team 103 representing the prosecution, Team 112 representing the defense. And so congratulations just one last time before I tell you guys the results of the round. And so the winner advancing to the championship round, representing the prosecution in the championship round, Team 112. Congratulations, guys. Team 112, if you guys will just check into the Zoom room at around 3:45, and we'll do the same thing we did today. Congratulations to all of you. If you have any questions, I'll answer them now.
Congratulations, guys. That was so much fun to compete against you.
Yeah, it was a lot of fun.
That was
We learned a lot.
awesome. Good job. Good luck. We'll be watching. Thank you so much.
Congrats and good luck.